Mr. Chair, you have a quorum.
All right. I think we will stand at ease for a moment and allow the committee to populate and people to leave proxies and a couple to percolate up here from the Transportation Committee. So we'll be at ease. I'm not sure that we've got a, I don't think there are many concerns about this. I may be wrong, but I think we've got a substitute. Senator McDougall moves, Senator Howell seconds the adoption of substitute. All in favor signify by saying aye. All opposed? All right, substitutes before us. Tell us real briefly what your substitute does.
The substitute changes language so that there is little or no objection to this bill, Mr. Chairman. It basically better describes where these posters would be posted, especially in emergency rooms, where there is some sensitivity to how directive the language was before we made the substitute.
All right. And you read the bulletin board in the break room in the hospital.
I actually think a great place is in the bathroom for these posters, but yes, that's included as an option in this bill, and I'm happy to talk to you about the bill in general if you'd like me to.
Well, I think this bill simply requires posting of a notification of a hotline for human trafficking victims. Correct. And
in a multitude of locations where it's not currently required. Right now, it's only required at truck stops.
All right, and I think that, and I think that was my bill at one time, but I think some concern been expressed about the Christmas tree component of this, whether we're opening the door to an awful lot of additional notices for a lot of other things.
I think that's a fair concern. However, I would suggest that human trafficking is one of those issues that is an egregious societal challenge that we don't have a lot of solutions for. Most of them are on the side of prosecution and the law, and this gives people who may feel they have no other option an awareness that they do.
All right.
I think this is an important human interest, humanistic.
Anybody have any questions of the patron? Anybody wish to speak in favor of or in opposition to this real briefly? Like real briefly.
Thank you, Mr. Chairman, members of the committee. Bill Ray with the Virginia Catholic Conference. We support this. I can also say that Bon Secours, our Catholic hospital, support this bill. There were 89 victims who called in 2017 and made a tremendous difference for them. Thank you.
All right. Thank you. Anybody else? Anybody in opposition to the bill? Senator McDougall. All right. It's been moved and seconded. The bill be reported. Senator Howell? I'm sorry. Okay. All right. Clerk will open the roll.
Ayes 9, no 0.
Well, Mr. Chairman, all those things I say about courts aren't true. Thank you.
Just stick around. Stick around. Move to reconsider. All right. Senator Barker. We've got Senate Bill 392.
392. And I think there is a substitute
All right.
for this bill.
Is there a motion on a substitute? Second. All in favor of adopting a substitute signify by saying aye. All opposed. Substitutes before us.
All right. This bill addresses a situation where there's a minor who is coming up for involuntary commitment or petition relating to the mental health issues. This is not one of the things that went through the Deeds Commission dealing with things this past year. Sort of came up late in the process there. So actually, I volunteered to handle this within the Senate, and Delegate Bell is handling it within the House. We're both serve on the Deeds Commission. The situation is that right now, what the law says is that when a minor is subject to involuntary commitment or detention here, that an effort has to be made to notify both parents of the minor. What we've had is a situation where in Fairfax County, the magistrates have decided that unless you have actually been successful in notifying both of the parents, that they will not issue an order and go through.
And
with the
this
hearing.
allows a finding of a reasonable effort.
Reasonable effort and notification of at least one of the two parents. So.
All right. Steve, I think there were some concerns. This expressed the concerns that we had discussed. I hadn't seen the substitute.
One of the concerns we had before the substitute, Mr. Chairman, was the question of if one of the parents had run off or their whereabouts were unknown, whether a court could make a determination in that situation that a reasonable effort had been made. But I have not.
If at the hearing the court makes a determination that a reasonable effort was made, is that not addressed here?
I think that is addressed in the substitute.
Yes.
Okay.
On line 39.
All right. Anybody have any questions of the patron? I'm sorry, Steve, did I cut you off?
No.
Okay. Senator Peterson.
Just so I'm clear, reading this text, do you have to serve one parent and make an effort for both? Or if you can't find either parent, and also is parent inclusive of guardians?
Yes, guardians would be relevant if they had the status there as parent. And a reasonable effort must be made to serve both. And basically the way it would be implemented is you have to have at least one that you are successful in serving.
But you have to serve at least one.
Right.
This doesn't say that, though,
It
does
doesn't
it,
say that here. This just
Okay,
says
that's fine.
reasonable efforts for both.
counsel?
Okay.
Wouldn't this allow a finding by the court that that neither parent was able to be served?
That's correct.
Is that your intent?
That was not the intent. No, I'm sorry. So we can.
All right. I tell you what, let's, unless there's a quick fix. And to Senator Peterson's point, maybe that he likes it better that way.
Well, it may be, if the intent is to ensure that at least one parent has been notified, on line 40, you would add language to that effect.
Mr. Chairman,
Senator McDougall.
what happens if the child is staying with a family member, the parents are traveling out of the country, and one of these situations arises? There's no way you could get notice. So as we move down through the process, if the direction is going to be one has to be served, I'm probably not going to be able to support that.
I was just, the situation that we've
requires
encountered has
both.
been when they've been able to serve one parent, but have not been able to locate the other parent. So that was what I was responding to here, so.
But under current law, you're telling us that some courts require proof that both
Yes.
parents were served.
Yeah, not all, but that has been some courts, and Fairfax was one of them.
Right.
That has been the interpretation. And so that what has happened is that a number of minors have, not gone through the process because they could not notify one of the two parents.
All right, Steve, do you believe that under current law, there's a reasonable interpretation that both parents have to be served?
Yes.
Okay. Both parents have to be served.
Line 36 says, "and the minor's parents," plural.
And, Mr. Chair, what if one parent is estranged from the other and the custodial parent seeking parental termination? That language, my understanding is that this is only a problem in one jurisdiction, and the special justices in that jurisdiction are having the problem, but the language lends itself to interpretation that those guys might have it right.
All right. Sir McDougall? Do you want the amendment to deal with one?
I think it says they may proceed, where
Okay. Senator McDougall has moved to report as it's written. Now, before we ask for a second, I take it that folks behind you support this bill? Anybody oppose this bill? All right. Senator McDougall's made a motion to report the substitute in the form before us. Is there a second? Second. It's been moved and seconded to report the substitute. Clerk will open the roll. We liked your mistake.
Thank you.
All right.
I appreciate it.
Oh, I'm sorry. Can you note Reeves as a yes? Thank you. Oops. You want to? All right. All right. Next, we've got Senator Wagner.
Thank you, Mr. Chairman. I have Senate Bill 890. And just responding to the snarky comment I thought I heard over on my right, your left, Mr. Chairman. I take great pride in not haunting this committee. Probably in the 1990s, I did one, had
And we may give you
had
a
an
reason not to
experience
come back.
but you know, after 10, 11 years, sometime in the 2000s, I got the same hankering to come here. And you know, it's been another decade, Mr. Chairman. I thought I'd haunt you and come visit you again. And quite frankly, what brought me to this point to want to come see you again is a constituent of mine who's made a very, very compelling case about her son, who has been incarcerated for decades.
Senator Wagner, I apologize. We may want to get Senator Marsden down here. Doesn't he have an identical bill? You authorized to speak for Senator Marsden?
No, I didn't even know he had a bill like that, but I can be your sergeant at arms. Go grab him. If you
It
want
is
to.
a bill that he has introduced before,
Oh,
I do believe.
already I'm getting cold feet here, Mr. Chairman, but
And it may be that we can request that he come over. And I will tell you that my understanding is that this addressed an issue that involved, my understanding was some authority that indicated that our practices were unconstitutional, that they have now been declared by the U.S. Supreme Court to be constitutional.
I'm not suggesting whether they're constitutional or not constitutional. I'm just making the
Okay.
opinion that this is a juvenile who committed a rather heinous offense, and I'm sure there are several others, but has done 25 years. And I would assume that given that it was a juvenile status, that perhaps we look at the opportunity to grant him parole, and that's all this bill does. And I'm sure the parole board can vet out whether or not he or she is in the appropriate position to be released back into society under the terms of the parole, or whether or not, based on the actions while he was incarcerated, that he remained remanded. But understanding that he, is a juvenile, and certainly I've supported the abolishment of parole, but, in a special circumstance of a juvenile, perhaps we ought to take a second look. That's what this bill does. I'm not going to challenge the constitutionality, the unconstitutionality of the laws. I'm just saying that, someone who served 25 years as a juvenile, it started in as a juvenile, and given that this record while he's incarcerated would indicate he might be all right to do that.
Senator Wagner, I will tell you that This committee has actually supported this bill in the past. Last year it reported out, I think, 10-5, and out of the Senate, 28-12, but did not fare so well down the hall. And more than happy to wait until Senator Marsden gets here before we take a vote. Maybe we could hear if there are those who would like to speak in favor of or in opposition to this bill.
I didn't really line up a whole lot of people, but if there's people who here who generally haunt this committee that love to speak on these things, I'd be
I
delighted to
think
hear
there
from
may
me
be
to
some
say.
interested parties.
I will turn around and see if there's anybody behind me, Mr. Chairman. And there is.
Hello, Mr. Chairman, members of the committee. My name is Kevin Maurer. I'm with the Virginia Catholic Conference. We do support the bill. We're talking about a very different person than the child who committed this crime 25 years ago. We believe in second chances and the grace of God, and we would hope that the Commonwealth would extend at least the possibility of parole for these people. Thank you.
All right, thank you very much. In support of this bill?
Mr. Chairman, I'm David Ledbetter. I'm the Commonwealth's Attorney of Waynesboro. I'm coming here as an individual Commonwealth's Attorney and not a member of the association. The association is coming out in opposition. Another member will speak. I come forth today because as a prosecutor, I'm a pragmatist. I've read the decision in the LeBlanc case that went up to the Supreme Court where they ruled our practice of making juveniles eligible for geriatric release as constitutional, or it stands under a habeas review, which is a very deferential review of the state Supreme Court ruling. I read the Supreme Court opinion as saying if this issue came up to us on a direct appeal, we may very well have a very different ruling and rule that your system is not constitutional. I like truth in sentencing. I like finality of judgments. I like telling victims when somebody's getting life, life means life. What I dislike less than going away from that is resentencing. So if we're faced with a situation on a direct appeal and the Supreme Court rules that our system under geriatric release is not constitutional, we're faced with resentencing these juveniles that we may have sentenced 10, 15 years ago, and a resentencing is the worst thing we can do to a victim's family. Our evidence isn't there, people die, things go away, and it can come out with a very different result. The 25-year rule that I urge you to adopt is among the toughest in the nation, and so I am speaking in favor of the bill.
All right, thank you, Mr. Ledbetter. All right, next, in opposition.
Nathan Green, Commonwealth's Attorney for the City of Williamsburg and James City County, speaking on behalf of the association. The association, well, we did have very vigorous debate on this issue. It took a consensus that we do value truth in sentencing above the situation Mr. Ledbetter just pointed out, the ambiguity or the uncertainty of what may happen. What we are valuing is that truth in sentencing, and so we are asking you to, or we are in opposition to the bill.
Yeah. All right, Sarah Wagner.
I just deputized the sergeant at arms here, Mr. Chairman, and sent him over to see if he could round up Senator Marsden.
I think he's on his way, and we'd be happy to maybe take up Senator Wexton's bill if she wouldn't mind standing down once Senator Marsden shows up.
I'm not sure it will take that long, Mr.
Oh,
Chairman.
okay.
So,
Well, in that event, we'll suspend on your bill and come back to it.
Get all your negative action out on Senator Wexton. I'll come back and see you.
All right, Senator Wexton, 440.
thank you, Mr. Chairman. This is Senate Bill 440, which I certainly was not trying to deprive the Courts Committee of this
Here
bill.
we go. I'm sorry. Senator Marsden, we appreciate your presence. We're taking up your bill, what was it, 890, and you're 239. We've already heard from those in support and opposition. It's a familiar bill from last year. As I pointed out, it passed this committee and passed the Senate. And if you want to make any closing comments, we'd be happy to hear from you again this year.
Well, thank you, Mr. Chairman. I'll be very brief. I better be very brief. The issue, here also is one where, a kid at age 15 who gets sentenced to life without parole, or 17 gets 40, 50 years. You get sentenced to the same kind of offense when you're 40 or 50 years old. You're going to be eligible for geriatric parole at age 60 in 10 or 12 years. If you're a kid, it's going to be 45 years. We desperately need to have a policy in this Commonwealth to deal with this. We can't just let it go back and forth in the courts forever. Let's come to some kind of final determination here. Let's give certainty to people to know what the deal is, so Commonwealth attorneys can tell their folks what it's going to be with a juvenile sentenced as an adult. And I would rather see the parole board deal with this than have a whole bunch of rehearings. And so that's all I have to add. I hope that's not too redundant. And
Mr. Chairman.
Senator Sasslaw.
Dave, let me ask you a question. As you know, you can't execute, minors, okay? So let's suppose you got a case, a Malvo. He killed 5 or 6 people. He admitted to that, okay? And because he was under 18 at the time they were committed, he got life without parole. Now, the courts have said, I guess, that they get a rehearing. Is there any rationale that you would ever have for releasing a Lee Boyd Malvo?
Senator Sasslaw, you can never say with certainty, but I would assume no, that people are not going to let a Lee Boyd Malvo go home. It just is,
Is this aimed at where it's a robbery or something like that as opposed to murder?
These things are all over the place. There was just a pardon granted for a young man who was a participant in an armed robbery at the age of 15 with 2 18-year-olds who stood there with a gun. It was wrong. He was offered a 14-year plea bargain. He turned it down.
I remember that.
And for whatever reason, the judge gave him 6 life terms and 118 years for his role in the robbery. So you've got that extreme, and then you've got the Lee Boyd Malvo, and then everybody else in between. And just having a consistent policy that our courts can rely on and not put them in the situation of if we have something that goes to the Supreme Court and it's a direct appeal and not a habeas appeal, then they're going to order rehearings, and that puts a tremendous burden on our court system. Other states have come up with a solution. I think this is a fair one, and I'd urge you to support
Senator
it.
McDougall, then Senator Peterson.
Mr. Chairman, is this exactly, Senator Marston, is this the exact language that we saw last year in your bill?
Senator McDougall, yes, I believe it is. I just turned in the same legislation.
Mr. Chairman, if it is, then I'm going to move to report.
Sir Peterson.
Yeah, let me ask one question before we vote on this. Lee Boyd Malvo, and wasn't he tried as an adult?
No.
Yes, he was.
Yes, he was a
Yeah, he was
juvenile at the
tried as an
time,
adult.
He was
tried as an adult.
adult.
This bill is all about juveniles who were transferred, when they were juveniles, transferred to the adult court. And in the Miller and Graham and rulings of the Supreme Court, they basically said any kid who gets a life sentence,
Even if they're tried as an adult?
even if he's tried as an adult, because he was a juvenile at the time, should have some kind of a meaningful opportunity.
Senator Norman.
Mr. Chairman, I would move that we roll Senate Bill 239 into Senate Bill 890 and report the bill.
All right, is there a second? Second. All right, it's been moved and seconded. Clerk will open the roll. Yeah, got it.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. I'll let you
All right.
figure out who Felix Unger and
right.
Oscar Madison is in that group. Okay.
Okay.
Senator Wexton, Senate Bill 440.
Thank you, Mr. Chairman. Senate
All right,
Bill.
so this basically removes from the list of school boards that are required to get permission to file suit from their local governing body, those who are elected. So the only ones that requirement would apply to are appointed school boards. Is that
That's
right?
correct. And
Okay.
it's only initiating a lawsuit against another governmental entity,
All right.
not against a private entity or individual.
Where has this been a problem?
Well, I'm carrying this bill at the request of the Loudoun County School Board. This arose out of a lawsuit filed by a private citizen against the Virginia Department of Education regarding maintenance of privacy of certain information regarding Loudoun County teachers. And the law was not clear about whether Loudoun County needed to seek advance approval in order to even intervene in that lawsuit, because they were intervening in, and naming the Department of Education as a potential party in in the lawsuit. So they were concerned because it jeopardizes the timely filing of suits, and if they had been denied that opportunity to participate, they would not have had a voice or any sort of standing in that
But don't
pending
you think
lawsuit.
that that would be good cause for a judge to allow late intervention if the school board just took longer to get permission from the Board of Supervisors?
Mr. Chairman, we don't know, I don't know what would happen in that instance, but the law is not clear whether they even needed to seek that prior approval before intervening in that lawsuit.
So why would you just repeal it for elected school boards and not for all school boards? How many would that leave subject to that requirement? Not many, I don't think.
I don't think that it would leave very many, Mr. Chairman. The feeling among the folks on the school board was that perhaps this is a holdover from the time that we did not have elected school boards in Virginia. And that's why they had to seek that prior authorization before getting involved in a lawsuit.
All right. Anybody have any questions? Anybody wish to speak in favor of or in opposition to the bill? Step right up. I agree.
Not much.
To the rest of
Yeah, no, I wouldn't go that far. Mr. Chairman, Ron Jordan, representing Loudoun County Public Schools. The senators did a good job of explaining the rationale for bringing this. We had a citizen who was intent on going after certain teachers and using information, all the personal information the citizen could acquire, and posting it on social media, and sued the DOE for trying to get tracking information on student test scores.
Ron, weren't you able to intervene in the case?
They did. They went ahead and did it anyway.
You have any reason to believe that you wouldn't have been able to, even if it had taken a little bit longer?
Counsel for the board thinks that they were skating on a little bit thin ice when they did it.
Oh, it would make you nervous.
Yes.
I get that. Okay, thanks. Anybody else in favor? In opposition? Yeah, I'm sorry. Step right up.
In favor line. Mr. Chairman, Stacey Haney with the School Boards Association. We're also in support of the legislation for the reasons that Senator and Ron stated. And in addition, as you know, with school funding, the localities appropriate funding to the school board, and then it's up to the school board to determine how to expend that funding, and that includes their legal budget. And Article 8, Section 7 of the Constitution of Virginia puts the authority over running the schools with the school system, with the school board, and we think that ought to include determining when appropriate to bring suit if that's what the school board determines is necessary. And there could be situations where the Board of Supervisors might, for political reasons or otherwise, not authorize the school board to bring suit. But if the school board can do it within its budget, which it's constrained to stay within its budget, then that ought to be a decision of the school board.
Can you point to, is there a case where this has actually impacted the rights of the school board?
Not that I'm aware of, Mr. Chairman.
And second, can I ask you, is there any reason to have a different treatment of elected versus non-elected school boards?
My understanding is the same as the senators, that it was, that this may have originated when school boards were appointed, and that because of the connection between an appointed school board and the locality is different than the connection between an elected school board.
All right, thanks.
Thank you.
All right, in opposition.
Good afternoon, Mr. Chairman and members of the committee. I'm Janet Arison with the Virginia Municipal League. We do oppose the bill, and it comes down to the funding that goes to the school board, and that does come from the local governing body. And state and federal money would not be able to be used for these lawsuits, but local money would, and that local money is coming from the local taxpayers. Thank you very much.
All right, thanks.
Thank you, Mr. Chairman. Chris McDonald, Virginia Association of Counties. I want to associate ourselves with the remarks from my colleague from the Virginia Municipal League. Also want to iterate to the committee this afternoon that 82% of school boards are elected, which would mean this would affect 130 some school boards, representing a radical departure from what has been sound policy for quite some time. Thank you.
So you all have to work together.
There is a restriction.
Under
Oh, no,
current
sir.
law. No, I mean under current law. You have to work with the school board.
Oh, yes.
In making those decisions.
Yes, sir. But again, this
And
is.
it's worked well.
constrains.
Awesome.
Oh, yes, sir. Thank you.
Mr. Chairman, Chris Costa with Fairfax County, and for the reasons already stated, the board's in opposition as well.
All right, thank you. All right. Anybody have any questions, motion?
Jim, I can't believe I'm going to vote with the municipal league.
You're welcome, Senator McDougal.
Mr. Chairman, this is editorializing, but I live in a jurisdiction that did not decide to go with elected school boards, and I have jurisdictions that did, and I don't know that that was our best decision to move to have elected school boards, because so much, all the funding, we don't give any funding decisions to the elected school boards, and I think we split up that decision and built in some conflict where we probably shouldn't have. So you didn't do that, that's not your fault, but I don't know that in increasing that potential conflict over funding is a good idea. So I'm going to gently move to PBI.
All right, is there a second?
Well, you would take that part.
All right, it's been moved and seconded to gently pass the bill by indefinitely. Clerk will open the roll.
No, it wouldn't. It hasn't happened in 46 days, have it?
All right.
Hasn't happened yet.
Bill's passed by
Thank you,
indefinitely.
Mr. Chairman.
All right. How many bills do you have, Senator Serbell?
How would he tax?
He actually only has two.
They're pretty quick.
All right, you're telling me.
No, because they got to run for reelection, that's why.
Senate Bill 86.
I'm talking about
think
elections.
it's
We're going to 86 it?
I hope not.
That's why, they got to run for reelection.
So Senate Bill 86 is a bill that this committee has passed twice in the last 2 years. Last year, it got out of the full Senate 2911. The year before
By the
that,
skin of its teeth.
2812.
8 to 7.
Right, and I'm hoping that Senators Peake, Stanley, and Stewart are still with me. But basically, what this bill makes an 18.2272 violation for driving after your license has been forfeited, the same as driving on suspended. Driving on suspended only applies on a public highway, but an 18.2272 violation applies anywhere, including your front yard. So if you're convicted of DUI, and even if you get a restricted license, you're not allowed to operate a tractor, a riding lawnmower, a forklift at work, basically any type of motor vehicle operated anywhere, even if it's on your own personal property or your company's property, is illegal under 18.2272. So this just makes the two statutes the same, so that the driving has to be on a highway. The Commonwealth attorneys are going to say that this opens up the possibility that somebody could drive their car around a parking lot or a shopping center or something. Obviously, sooner or later, somebody's going to get to that street, and then they're breaking the law if they're in violation of their restricted license. But because these two statutes are drafted inconsistently, it creates this wacky result that you can't drive a riding lawnmower.
Anybody have any questions of the patron? All right, anybody wish to speak in favor of the bill? In opposition?
Mr. Chairman, I just have one brief
Senator
question.
McDougal.
So if we pass this, then you would be able to get a DUI driving your lawnmower around your front yard. But if you've been convicted of a DUI, then you would not be able to be convicted for driving that lawnmower around your front yard.
Mr. Chairman, I want to help Senator McDougal out with that conundrum. And I've got a bill that will address the first part of that.
Right.
And it's limited to lawnmowers, right? All right. Those who wish to speak in opposition of the bill.
Reckless driving on the lawnmower.
Good afternoon, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, speaking on behalf of the Virginia Association of Commonwealth Attorneys, excuse me. We are in opposition of this bill. I would point out that the legislature put this crime in 18.2 because they did want to recognize it as a crime and punish it more harshly, or look at it more harshly than it does 46.2 300 violations. These are individuals who have shown a lack in judgment, have been convicted of a DUI, have lost their ability to drive, or have had it restricted to include interlock or some things that will help keep the public safe. And this is a bill that would minimize our ability to keep the public safe. I represent an area that has Busch Gardens with a large parking lot and a park that serves alcohol. This would allow an individual to go into the park, consume alcohol, come back and drive his car amongst the citizens that went to the park as well. And even though he was not supposed to be driving, even though he was supposed to have ignition interlock, he would not be in violation of this law any longer because this is open to all private property. We would not have the same position if the bill was limited to your own property or to golf carts or to tractors, but it's not. It opens the door to operating all motor vehicles on all private property, and there are a number of citizens that make use of private property that will no longer be protected when this legislation
Mr. Chair.
privately done.
All right, Senator Deeds.
Then you would agree with me that right now, if a person has a DUI and his license is suspended, and he's a farmer, he can't operate his tractor in the hayfield when his license is suspended, without an ignition interlock device on the tractor.
Without, in the hayfield, it's.
In the hayfield.
I would agree, but this bill does not limit it to that situation. It also opens up those situations that I've described as well. And I do not, I apologize, Mr. Chairman.
All right.
I don't believe that there's been a problem with a number of people being arrested and prosecuted for driving or farming on their private property. But I can tell you in Williamsburg, we have a number of people that are arrested for driving drunk or driving restricted in Busch Gardens parking lot.
All right, thank you. Excellent.
Mr. Chairman, my name is Kurt Erickson. I'm with the Washington Regional Alcohol Program, which is a Virginia nonprofit fighting drunk driving. I'm also representing Mothers Against Drunk Driving here in Virginia. Echo the Me Too sentiments from the Commonwealth Attorneys Association. I think the apt analogy, as they mentioned, Busch Gardens. The average BAC of those tested in Virginia is not 0.08. It's not hovering around 0.08. It's actually above 0.14. So I think the analogy is apt that somebody driving across Busch Gardens parking lot with a 0.14 BAC versus a neighboring roadway constitutes the same risk. So thank you.
Thank you. Yes, ma'am. And I'm not going to cut you off.
Mr.
quite
Chairman,
yet.
members of the committee, my name is Martha Mead. I represent AAA, and for all the reasons already stated, we oppose the bill. We would, however, be open to clarification for farm use, et cetera. Thank you.
Okay, thank you. Senator Norman.
Mr. Chairman, just to put it in perspective, my Commonwealth attorney, who I have one or two cases with, it's painful for me to rise in support of him, but I will do that. And it's not just a unique situation, but to put it in perspective, at Busch Gardens, they have enough roads where they run a 10K within the park, and there are literally thousands and thousands of people that attend there, and that venue is not unique to Williamsburg, and so I'm sorry, Senator Serville.
All right,
Mr. Chairman.
Anybody have any other questions? Senator
I have
Edwards.
A question to the sponsor of the bill.
Yep.
Is there any amendment to limit it to what I would affectionately refer to as the hayfields or something like that? Seems like most people agree you got to be able to ride your tractor, I guess, in a hayfield.
I mean, I could try and craft some
Lawnmower or
language to
something.
shopping centers or farm use or something like that, but that still wouldn't cover golf courses. And I mean, there's a myriad of different scenarios that can be affected,
Right.
which is the problem with
That's
it.
why
Like,
there's a bright line.
right.
Senator Stewart.
Thank you, Mr. Chairman. Senator Serval, have you looked at 46.2-100? Doesn't that allow for a locality to make an area that's designated for public use? And if I can't remember if Busch Gardens is where it's in, but if James City County, or couldn't they say that the roads and parking lot of Busch Gardens is designated for public use by ordinance, and therefore that would solve the whole problem?
I don't think so.
I mean, it supports your bill.
I get that. I know you do. And I think you asked a similar question last year. And I'm not sure if there's a provision of the code we could tie it to other than the way 46.2301 is already drafted, the driving on suspended statute, which says public highway.
All right. Okay.
But I've thought about it because they've raised these concerns before.
Senator Norman.
I could have 45 seconds to wrap up at some point.
Mr. Chairman, I think to put a finer note on Senator Stewart's question, in my communities, we have a lot of gated communities that have private roads.
Mhm.
Local governments by ordinance can bring them in, declare them the highway right in second definition of 46.100. So there's the ability to do that. I don't think we're going to be able to get to the point for this.
All right, real quick.
45 seconds, yeah. First of all, I also tried cases against Nate Green before he came to Waynesburg, when he's a Fairfax County Assistant Commonwealth Attorney, so, but I'm still happy to fight him. But number one. Number
30
two.
seconds.
Busch Gardens, nobody would currently be allowed to drive on restricted license to Busch Gardens. That's not a current condition, is I want to go to an amusement park. So the person could be nabbed as they're entering or exiting and still be in violation of 18.2272. So I don't think the Busch Gardens scenario is really an accurate one. And, you know, we passed this last year. I was hoping with the changes in the House, we might have a chance to actually get it through this year, which is why I put it in for the third time. Otherwise, I wouldn't have done it. So I think, you know, to me, it's a change that needs to happen. I would hope those of you who stood with me last year would stay with me.
All right, bill is before us.
Move to report.
Been moved and seconded, the bill be reported. Clerk, open the roll.
Thanks a great bill.
Oh,
Oh, not this time.
oh, I got you? You want me? No?
Peek, you flipped on.
Okay.
Ayes 5, noes 10.
Oh, wow.
All right,
All right.
Senate Bill 94.
94 is really simple. 94 is just an attempt to try and make clear that expungements, that traffic offenses can be expunged. There's some Commonwealth's attorneys that think that it's not, and I just think it ought to be clear that they're included in expungements. So if you're found not guilty of a traffic offense, you can get that expunged too.
All right. Anybody have any questions of the patron?
Mr. Chairman,
Yes.
what if you're found, what about a protective order, an emergency protective order if it's not?
Well, I know Senator Marsden had a bill about protective orders that I worked with him on about 4 years ago. Those are quasi-criminal civil things, and they're not included in, you can't expunge a protective order. That's one big problem with a dismissed protective order. I've tried to figure out a way to make that happen, but there's a lot of problems wrapped up in that. But I will say that the judges who I've talked to about EPOs, which is your question, is that because of the way the expungement statute is written, if the EPO is tied to a criminal charge and you get the criminal charge dismissed, the EPO goes with it and can get expunged also. So I think EPOs can be expunged if the associated criminal charge goes. But if it's a PPO, a domestic or a child protective order, there's no authority to expunge those right now. And my bill has nothing to do with that.
So, and what kind of administrative burden is this going to place? Maybe state police, you have any comment on that?
I can also say I've talked to the state police, and they already do expunge traffic offenses already. So when ordered to.
Mr. Chairman, Keenan Hook, the State Police. We do occasionally get an order to expunge a traffic case right now. They're so infrequent that they are no burden at this point. However, there are, as last year, there were 200,000 dismissed traffic infractions across the Commonwealth that, while Senator Surville says this is declarative of existing law, and he may be right, the department is concerned that this is, that not everybody understands the law the way Senator Surville does, and therefore this will potentially dramatically increase the number of expungements we get. I would also say, Mr. Chairman, that the department is hesitant to embark on this because we are not the custodian of the records in these cases the way we are in a criminal history case. We do have the criminal history database, but we do not retain records for traffic infractions. The only records we would have would be for summonses we issued.
All right. And, you know, I mean, for me, I mean, expungement is removing a stain on your personal record. And I'm curious, I mean, we allow expungement of felonies, so that's a big stain. There was legislation that came out earlier during session from Senator McDougall allowing expungement of alcohol and certain drug offenses that are misdemeanors. Those are significant stains. I mean, why would we do all traffic offenses before we do all misdemeanors, all criminal offenses?
Mine, it's still just acquittals. It's not.
I understand. But I'm talking about acquittals of misdemeanors, all misdemeanors instead of just the drug and alcohol misdemeanors. I mean,
All misdemeanors are currently included.
Mr. Chairman? I think what Senator Obenshain is trying to articulate is if we're looking to expunge things, maybe the possession of alcohol, possession of marijuana when you're younger might be the better direction. But my bigger concern is state police is not custodial keeper of these records. So who are you expunging? Because the entire expungement statute is set up around the state police. So if you get a following too close and you have that dismissed after a trial, witness doesn't show up, or the judge agrees with you, DMV is the one that puts that on your record, not the state police, because there's
Right.
no criminal impact. So how do we go through an expungement of an entire different agency?
Okay, well, to your point, that they already have to expunge. First of all, the state police does some records of their own they have to expunge, but they also manage the entire expungement process. So they send out notices to local law enforcement, to sheriff's offices, to DMV, to the Supreme Court, and then they manage the process and make sure that they get the records back, that it's been confirmed. There's actually a process set up in the CFR about that. They already expunge records that they don't have custody of, because they don't get custody of a marijuana possession that's charged by summons. They also don't have custody of for example, reckless driving, class 1 misdemeanor that's charged by summons. They don't have custody of that record either. And so they're already expunging records they don't have custody of because they manage the process. And so all this does is just makes clear that that traffic offenses are included within the process they have to manage. So they already do what I'm suggesting. I just wanted to make it clear that they can, so we don't have to argue about it anymore.
Mr. Chairman?
Sir Edwards.
The whole idea of expungements is fairly new in the law. Infractions are not criminal offenses. We've started out with expunging felonies when you're found not guilty because it affects your employability, as a stain on you as a person. And people have not gotten jobs, even though they've been acquitted of things like malicious wounding. I know situations like that. Until they come into court and prove to a judge, hey, this has affected my employability and it affects my reputation. Infractions like speeding tickets, parking tickets, spitting on the sidewalk, things don't really, everybody does them. It's not exactly a stain on your reputation because you've got a speeding ticket. And I'm not sure, I know the workload issue is one big issue, but is my understanding, expungements, you go to circuit court, it's not that hard, but you got to have a circuit court judge to decide these things. And I don't know that we want to go to the situation where circuit court judges are deciding to expunge 10 miles over the speed limit kind of things. I mean, this is history. It happened. It's not really going to keep you from getting a job. I know, for example, when the FBI goes and checks somebody out who's up for, say, a federal position, they kind of expect you to have something on your record, like exceeding the speed limit or something like that. In fact, if you go to the FBI, if the FBI checks you out and they ask you, have you ever been convicted of anything, and you say no, they're probably going to think you're lying because everybody's got something.
Mr. Chairman, I'll take that as a question.
And so, Mr.
I don't think he likes your bill.
I think the problem is, I'm all for protecting people's reputation, but I think we're going way beyond what the policy for expungements actually initially was. And so, wouldn't you agree?
Let's. No, he would not. Right?
No, I wouldn't, and I would say there's some jobs where lots of dismissed traffic tickets could cause you a problem, like being a taxi driver or a delivery service driver or something like that. So, and I would also say that I have a lot of clients with security clearances that this can present problems to.
All right. Is there anybody in support of this?
No.
All right. Senator Norman.
Mr. Chairman, I'm totally befuddled, so being in doubt, I'd move to PBI the bill.
All right. Is there a second? Second. All right. It's been moved and seconded to pass the bill by indefinitely. Clerk will open the roll.
Ayes 12, noes 3.
All right.
Okay, thank you.
Senator D. Steph. Senate Bill 57.
Mr. Chairman, members of the committee, I don't know how to follow that. I'm sorry. This is pretty much an easy one. I've worked on this for about 5 years, and I think we finally have it to where we have agreement from just about everybody. What we're doing is taking section 18.2.479.1 and putting it under 18.2.460. So we're taking the old resisting arrest and moving it under obstruction, resisting, fleeing from a law enforcement officer. And I think it, in my opinion, I'm not an attorney, but I think it makes the law a lot clearer and more logical and easier to read. We've got some speakers or supporters on this if you'd like to hear from them, but I've tried to make this real simple.
In fairness to Senator DeSteth, he inquired about carrying this over till Monday, and I discouraged it, but he wanted Senator Sheriff Stolley to make the trip up, who I understand supports this and helped you craft it.
Yes, sir, that's correct, Mr. Chairman. And I've, at his request, I asked to carry it over, but I'm more than happy to present it, more than happy to explain it.
Mr. Chair, Mr. Chairman, the sheriff has given me his proxy, so.
Senator Deeds.
This bill makes no substantive change in the law. It just moves language from one place to another.
From one section to another, which makes it easier to understand. And where we had before, what we had before was, it was under 18.2.479.1, and it was somewhat confusing when somebody was charged with resisting arrest. So this puts it under 18.2.460, makes it easier to understand and more logical.
All right, any other questions?
Mr. Chair.
Senator Deeds.
I'd like Mr. Benjamin to comment on whether this is logical and whether this adds confusion to the law or more clarification. What do you think?
Mr. Chairman, I think moving it to this section makes a great deal of sense.
Okay.
All right.
It does require that we insert 2 commas in the bill that exist in the current section so that someone doesn't think that a change was meant. And those commas would be inserted on line 37 after the word person and on line 39 after the word arrest.
Mr. Chairman, I move the 2 commas.
All right. Is there a second? All in favor signify by saying aye. Aye. All opposed? Those amendments are made. Anybody here who want to register their support for this bill?
Yes, sir. Sheriff's Association very much supports it. It's in a section now relating to jails. It makes more sense to move it. Thank you.
We're cruising, I believe. All right.
State Police Association supports.
All right. Anybody in opposition to the bill? Commonwealth's attorneys at peace with this?
We're okay with it.
All right. Is there a motion?
Move to report, Mr.
It's been moved and seconded. The bill be reported. Clerk will open the roll.
Mr. Chairman, members of the committee, thank you very much. Have an awesome day.
Thank you for your efforts. They paid off. Senator Mason.
Thank you, Mr. Chairman. I have Senate Bill 543, and we do have a technical amendment needed, sir.
519, first of all, I think we are going to take that up later, and you're giving me your proxy and permission to roll that into a bill that I'm carrying?
Seems advisable to me, sir.
All right, and Senate Bill 543.
Yes, sir, and we accidentally on line 32 left the number 4 out at the beginning of the sentence.
Is there a motion to make that amendment? It's been moved and seconded. All in favor, signify by saying aye. All opposed? That amendment is made. Did you get that?
Mr. Chair, could Senator Mason restate the amendment?
Oh, I beg your pardon. We're just adding a 4 on line 32. It goes 1, 2, 3. We whiffed a 4 and went 5, 6, 7.
Okay.
See, in front of
Number
in
4.
its order, it should say 4.
Okay, yeah, okay.
Okay. Senator, go ahead.
Very good. Thank you, Mr. Chairman, members of the committee. This simply allows us to set up temporary conservators by circuit court judges to protect incapacitated adults in emergency situations. So it may be that we are, and the conservator allows us to get to the financial record. So it may be that we see that
incapacitated adults being financially taken advantage of, but a more likely example is I'm 50, my father's 82, I'm taking care of him, paying his bills, he's living at home, and I fall out dead or something happens to me. This simply allows us a more expedited manner to get someone to the incapacitated adult and allow them to help them maybe pay their bills at the end of the month or make financial moves that may be necessary. At this point, my local officials tell me that under the current system, it can take up to a matter of weeks to get this situation and leave somebody in a financial.
All right, anybody have any questions of the patron? Anybody wish to speak in favor of the bill?
I'm sorry? Mr. Chairman, so Chris Costa with Fairfax County, this would help, our Department of Family Services says this would help our boards taking a position of support.
Okay, Senator Stewart. I'm sorry, yes, ma'am. Step up.
Yes, I'm Kimberly Irvin, Director of York Pocosin Social Services. I'm here representing the League of Social Services Executives and the Virginia Local Human Services officials, and we support this bill.
Have you all had this situation arise in which it has
Yes.
taken a period of time to get somebody appointed?
Yes, under the temporary conservatorship, which already exists, and this is just for adult protective services, I've gotten examples from all over the state. This is just for 15 days plus a 5-day extension. And it's happening more and more as our population is, we're getting more and more of an elder population. So yes, we're definitely getting a lot of these.
Okay, Senator Stewart.
I'm sorry, I really had a question for the patron.
Yes, sir.
Senator Mason,
Yes.
and maybe I came on late, but can they not already do everything under Section 32 and 34 that you would be able to do under your new Sections 5 and 7? Or does this just help clarify it for the court?
I'll take that one, sir. Right now, it's just a temporary guardian. And the guardian, a way that I think of the distinction is that a guardian actually protects the person, whereas the conservator protects the person's property. So that's, dealing with the money. It allows us to, I'm sorry, sir.
I'm sorry if I may. It says in the order, the court shall appoint the petitioner or another interested person as temporary guardian of the adult with the responsibility for the adult's welfare and authority to give consent for the adult for the approved adult protective service at expiration of the order. So you don't think that's enough, I guess?
No, sir. It will not allow us to access the income or any of the resources. So what happens sometimes is that the caretaker dies. And so we get the call because there's no one to take care of the person. It's an emergency situation. And we can't access their, to find out what their Social Security income is. We're not able to access what their resources are. So that's the problem with not being able to have the conservator. We can't access that financial information to even determine what they might be eligible for. They could be eligible for Medicaid, auxiliary grants, that kind of thing.
All right, thank you. Anybody else have any questions? All right, bill's before us. Second. All right, it's been moved and seconded. The bill be reported. Clerk will open the roll. So Mason, thank you very much.
Thank you, Mr. Chairman, members of the committee.
All right. I guess Senator Favola, I don't see her here. Senator Deed, 685.
Yeah, if I can do the bill from here. Mr. Chair, this bill I introduced at the request of the Commonwealth Attorney of Bath County. Last year, we imposed requirements on all Commonwealth attorneys to do certain worksheets for restitution. There are 3 Commonwealth attorneys. At the time I was elected Commonwealth attorney in Bath County, the majority of Commonwealth attorneys in the Commonwealth were part-time. But there are only 3 part-time Commonwealth attorneys left. 2 of them are my constituents. We impose a significant amount of extra work on those people. There's more personnel in the clerk's offices to do the worksheets, and so his request was that we put the work in the clerk's offices and those part-time jurisdictions. This affects Bath County, Highland County, and Craig County.
What do they think?
And I don't know whether anybody is here to speak in favor of the bill
Mr. Chair,
or in opposition to the bill?
I've had a little bit of conversation with Mr. Dix about it, and he was going to check with the clerks, but I've not heard back from him since then.
And I would say, and I mean, I think I carried that bill last year.
I think so, yes.
And part of the challenge, and it was a bill that went through a lot of different iterations. And I think that there was a lot of discussion about who should have that responsibility. And I think that it was decided that it was not something that should reside with the clerks because they don't deal with the victims. It's the Commonwealth's attorneys who deal with the victims. And I think some of the stakeholders might feel pretty strongly that this is undoing some of the work that we did last year to, try and make sure that those victims who were entitled this restitution are protected.
And Mr. Chair, I certainly don't want to undo anything that was done, but there are only 3 part-time jurisdictions. And for the most part, I can tell you, in Highland County, it's a real estate lawyer, basically, and a secretary. That's the office. While in the circuit court clerk's office, there are 3 people. In the district court office, there are 2 people. In Bath County, there's basically a real estate lawyer and 1 secretary. And I think he's got a couple other lawyers that work with him, and they each have secretaries. But there are 3 or 4 people in the circuit court clerk's office, or 2 people in the district court clerk's office.
Well, maybe they have a pretty good working relationship with the clerk's office, and they can work something out.
Mr. Chairman.
They're just these 3 offices.
I understand. Senator Peake.
They run for this office. If they don't want to do the work, they don't have to take the job.
Mr. Chair,
Senator Deeds.
I appreciate Senator Peake's point, but we just imposed this burden last year.
Of restitution?
These restitution worksheets on the Commonwealth attorneys last year, they last ran for office the same time, well, and not the same time you did, but the same time the rest of the members of the Senate did, 2015.
Mr. Chairman, I would say if they have part-time jobs, they probably don't have a whole lot of people in the counties. If we discuss in other bills, there's probably not a whole lot of restitution. They can always step down.
Is this something that the Commonwealth Attorneys Association wishes to wade into or has taken a position? I'm not inviting you if you don't have a position.
We have not taken a position.
All right. All right.
We would love the position, go for everybody. All the clerks have to do all of them. We know that's not going to happen.
I don't think so. All right.
Move to report. Second.
All right, it's been moved and seconded that the bill be reported. Clerk will open the roll.
Of course, I'm like, if we can come in and bitch about it, they won't do.
Ayes 7, noes 8.
Close. All right. Do you have another one, or is that it?
That's it.
All right, next we've got Senator Favola. Welcome.
It's a very quick presentation.
Fantastic.
Very quick. Thank you, Mr. Chairman. I'm presenting Senate Bill 748.
There's a substitute. Is there a
Yes.
motion to adopt a substitute? Is it second? All in favor of adopting the substitute signify by saying aye. Aye. All opposed, the substitute is before us. All right.
Okay, Mr. Chairman, the substitute is a Section 1 bill, and it merely directs the Office of the Executive Secretary of the Supreme Court to convene a group of stakeholders to develop guidance for judges on handling petitions from convicted felons to possess, transport, or carry a firearm. Judges have asked for this guidance. It's pretty
Senator Stewart.
harmless.
Senator Favola, I'm curious, there already exists a procedure for exactly what you're asking here, and I have to ask this question. Are you bringing this bill because the governor restored the rights of 200,000 felons last year, and now you're afraid you're going to have a flood of people coming in with the restoration of rights to carry a gun?
I was asked to carry this by Secretary Moran.
That
and
answers my
that may-
question.
So that may be a part of it, but I didn't get into a full conversation. I just agreed to carry the bill, but
No
you may-
disrespect
you may know.
intended. I have the most respect for you of any member of the Virginia Senate, but I can see why Secretary Moran wanted this bill.
Yes.
I don't think it's a bad bill nonetheless, even though
Well,
Secretary Moran wanted it.
Let me ask, and counsel, you may be able to answer this. I mean, does guidance already exist?
I don't know.
Yeah, Mr. Chairman.
The judges have a bench book that provides guidance on a variety of topics. I don't know if that includes the restoration of these rights.
Mr. Chairman,
Senator Peake.
I have done a number of these gun restorations. You file a petition, you have to go to the state police and get a criminal record. You have to file all of that, you file it, you serve it on the Commonwealth's attorney, and then you have to have a hearing. And
what's
then
the
the judge
standard?
reviews, it's up to the court's discretion. Good discretion, the Commonwealth's attorney weighs
Good
in.
cause.
Yeah, and what has happened is Governor McAuliffe blanketly restored 200,000 people's rights to vote. And he wants them to vote, and now he doesn't want them to have their gun rights. He wants them to restore all the rights to affect elections throughout the Commonwealth and not possess a gun. And now they want to create a commission to keep the people that he's given the voting rights to from getting a gun, and I oppose this bill.
Okay.
Well,
Mr. Chairman.
Hang on.
Mr. Chairman.
The part of that answered my question, I appreciate all of it, but the part of that answered my question, I think, was the part that said that the standard is good cause. I mean, is that the standard, Steve?
Mr. Chairman.
Charles?
Yes, Mr. Chairman, that's the standard.
Okay.
Mr. Chairman.
So my question to the patron is, why do we need to do this if the standard is already established?
My understanding is that there's some question about interpreting the standard, good cause, and that there was some interest on the part of some judges in having more guidance. And I can't explain that more than what I have just said.
And I know you're not afflicted with a law license.
Law degree, yeah.
But, I mean, that's exactly what judges do every day, is make determinations of good cause. And if we got judges who don't understand what good cause is, I think we got big problems. Sarah Edwards.
Yeah, I've done these too, on more than one occasion. It's not a complicated process, but I don't see I don't know what the Supreme Court's position is. Might be good to ask them about this if they think it's necessary, but I see no harm in having them take a look at it with the judges. That takes it out of, by the way, the political issues we're raising here. Sure. Just because you don't like what the governor did on some matter doesn't have anything to do with whether or not we need a simplified or process.
We asked for it, and the Supreme Court is standing before the podium.
Good.
So let's hear what they have to say.
Yes, Mr. Chairman, Christy Wright, Office of the Executive Secretary of the Supreme Court. We had concerns with the original bill. We continue to have concerns with the wording as far as guidance documents. And having the Administrative Office for the Supreme Court be the one to hold this, to conduct this group, and to come up with this guidance, when it's really a substantive policy issue. And I think if there needs to be further clarification about who and when a gun should be returned, that's really something that should be for this body. And if you want guidance to the judges, that should be placed in the statute and not through the Administrative Office for the courts.
Well, Mr. Chairman, I have a question.
All right, Senator Edwards.
Yeah. Is the process, have you had any questions from judges and all about that we need to clarify the process? I know the Supreme Court does a lot of work in terms of providing process issues and forms and all the rest, but is this an issue that?
I am not aware of it. I'm not aware that has been a concern. I'm not saying that, that they haven't expressed it to Senator Favola. And we do have bench books, but that's usually very much on process. Or if there's already something set out in statute, it restates it in a kind of a easier to read format. But to develop what is actually good cause is much more substantive. And again, I think that's a policy decision, more appropriate for here.
All right. Senator Stewart.
Thank you, Mr. Chairman.
I'm sorry. Senator Chapin has been trying to get my attention.
Mr. Chairman, there's another issue here that I want to bring to the committee's attention. I've done these in any number of jurisdictions, and the U.S. Attorney's Office has a policy about them too. These rights aren't granted back insofar as the federal government is concerned, but there's an understanding with the federal government right now, with the good cause shown, with the hearing in circuit court, and the situation as it currently is, that the ATF and the U.S. Attorney's Office will not intervene and will not go out and prosecute people who have met that standard and have had their rights restored by a circuit court judge. So when you have this proceeding in circuit court, you're not talking to an empty vacuum. The Commonwealth Attorney is there. The Commonwealth Attorney will bring any number of records depending upon the convictions that the individual has. The Commonwealth Attorney will either oppose you or possibly agree if it was a very minor felony conviction. But you're required in all the courts that I've done this in, the judges expect you to bring witnesses. They expect you to show that the individual has been rehabilitated, that they are working, they're making contributions to society, that they don't have an alcohol problem, they're not using illegal drugs. There's a big hearing that occurs in these proceedings right now in order to be able to show good cause shown. And the circuit court judges certainly don't take it lightly that they're granting someone their firearms back. They take that obligation that they're taking upon themselves very heavily. So I think that this is a true Pandora's box that could be opened up here that the federal court system might look at too, and we might get something we really don't want. Any of us don't want.
All right. Are there those who wish to register their support or opposition for this bill? Yes, ma'am.
Mr. Chairman, members of the committee, Nikki Zamosny, Assistant Secretary of Public Safety and Homeland Security. The administration supports the bill, and we thank Senator Favola for carrying it.
All right.
Thank you.
Anybody else? Anybody in opposition? All right, the bill is before us. Senator Peak?
Motion to PBI.
All right, it's been moved and seconded to pass the bill by indefinitely. Clerk will open the roll.
Ayes 10, noes 5.
All right. Thank you, Senator.
Okay, thank
and
you.
I appreciate your work. I mean, you moved a long way in your bill, so appreciate it. All right, next we've got, how about Senator Peterson?
Yes, sir.
224.
Mr. Chairman, members of the committee, actually, before I get to 224, I also had 273, which I'd like to carry over for the year. That was the construction trust
All
bill.
right, Senator.
272, I'm sorry, 272.
Senator Peterson moves, Senator Stewart seconds that Senate Bill 272 be carried over for the year. All in favor signify by saying aye. Aye. All opposed, that's carried over. Senate Bill 224.
All right. Mr. Chair, members of the committee, this is a unique, well, we spent a lot of time talking about civil forfeiture over the last few years, and I think we've had enough disturbing incidents that have been raised to this committee that is something that's been on our radar screen. But then one of the questions occurs, what happens if the government holds property but never files a forfeiture petition? So there's no finding of fact whatsoever. And the situation that happened in Fairfax County, of which I'm very, very closely aware, was there was a search warrant served against a local businessman in the summer of 2015. Both a laptop with his business information and $50,000 in cash was seized. There was part of an investigation, a criminal investigation. No criminal indictment was ever issued, and no forfeiture petition was ever filed. And there's a 90-day window to file that petition. So this came to my attention last summer, 2 years after the initial search warrant. I contacted the police, and they said the investigation was, quote, still ongoing. Well, We waited another 6 months and finally ended up filing a conversion action. The bottom line is, and that situation can play out separately, but I was really stunned to find out in the code that there is no mechanism whereby when the police seize your property and don't file a forfeiture action, that you can actually get the property back. And I've been through the code, I've looked at it, I've discussed it with circuit court judges. Other states have a mechanism whereby you can get the property back. And it seemed to me we need a situation in Virginia where if the police seizes your property, chooses not to charge you, but rather maintains an indefinite quote-unquote investigation, that you have a mechanism to receive your property back. And that is the context for Senate Bill 224.
Yeah,
Did you
Mr.
get
Chairman.
that property back?
No, not yet.
Mr. Chairman?
Yes.
Senator
I've
Edwards.
gone through this process. There is a provision to file a suit for the return of seized property, such as a search warrant seizure, case I had. The problem is, the prosecutor comes in, they haven't charged anybody, and they're not going to return the property. And there's no, and the official, technically, to return seized property is a practical matter after the case is over. Now, if the case is not going to be
The case never
prosecuted,
got
and
started,
that's
so-
exactly what happened in my case. And we ended up, a judge ended up kind of basically leaning on the prosecutor, said, look, I'm going to give you 30 days or some period of time to do something or not, and otherwise it's going to be returned. But the judge really just kind of did it. And you're right, we need some kind of basis. They can't just keep it forever and never return it and never charge somebody and never do anything with it.
Right.
Mr. Chairman,
Sir Pete.
Senator Peterson.
Yes, sir.
Exact same situation. And they keep it, and if it's a felony, there's no statute of limitations.
Right.
And so they can keep it open. This was a completely frivolous suit. They came and took all this stuff. It's 4 or 5 years ago. I went to court, like Senator Edwards said. Judge really doesn't have any authority to do anything because Commonwealth's attorney says it's still being investigated.
Right.
I approve of this bill.
Well, thank you. I approve of you. Thank you.
All right. Do you have a question, Richard?
I like your bill, but I do have a question. So if you've given the Commonwealth's attorney the ability to file a petition to stay the release of the property in here, and they've got to go to court.
Right.
They've got to prove his case to the judge. If there's an ongoing investigation, if I read this correctly, though, it's 1 year. Is that correct?
Right.
So the court can stay that for 1 year.
And to be honest, Senator Stewart, I would have much rather have gone 180 days. I think I did a year out of.
Well, here's my question. But
Sure.
what if for good cause they've got an ongoing investigation or an unsolved murder or something, and this is integral to that? I don't know. But again, should we be giving the judge discretion to look at that?
Senator Stewart, I would almost do anything. I would allow an ex parte, well, not an ex parte, I'd allow an in-camera hearing. I allow whatever. What I cannot have is for someone to hold property for 30 months without an indictment.
I agree with you.
You can't do it. It's un-American.
I agree with you. But I guess the thing I'm trying to say is there could be a reason.
And I allow them to raise this in court, and if they wanted to have an in-camera review, then I wouldn't have a problem with that. But to me, they've got to articulate a reason.
No, but perhaps I misread this.
Right.
So if the information's not filed within a year, then I can file a petition. You can file a petition for your client to release the property. The Commonwealth's attorney can then come in and file a response to that petition. You can have a hearing before the court, and the court can stay the release of the property for only another year.
Only a year.
Only a year.
I guess theoretically, they could come in and extend it a year after that.
But doesn't say that. So my only concern is this. There could be situations where the Commonwealth's attorney needs to hold on to this, and I'm in favor of making them make that case to a court.
Okay.
But I don't want to tie the judge's hands if we need to have that held on to. And maybe I'm reading it wrong, but that's the way I read it.
Would you be amenable to an amendment that would
allow repeat petitions?
Yeah, for a year at a time?
I'm fine with that. Like I said, a year to me is a long time to not be without property, but I'm fine with that, sure.
Well, all right,
I mean, 2 years is a long time to
while
hold
we
somebody's property.
cogitate over this, let's see, if folks in the audience wish to speak in favor of the bill.
Good afternoon, Bill Farah, ACLU of Virginia. Mr. Chairman and members, we support the bill.
All right.
Good afternoon, Mr. Chairman, members of the committee. Steve Rossi with the Family Foundation, and we support the bill. One of our principles says the role and jurisdiction of government is clearly prescribed by our Constitution and consequently should be restrained from excessive involvement in the lives of our citizens. So this fits that perfectly. Thank you.
Yes, ma'am. How long should we go?
Good afternoon, Mr. Chairman, members of the committee. Susan Lascalette, representing the Virginia Tea Party Federation, and we strongly support this bill. Thank you.
Thank you. How about a year at a time? All right. Anybody wish to express contrary view?
Mr. Chairman, members of the committee, Wes Nance, Commonwealth's Attorney for Bedford County, speaking on behalf of the Virginia Association of Commonwealth's Attorneys. And we are opposed to this bill really for two main reasons. First, the workload, the personnel responsibilities that this would put on our small and already strained offices, and then also perhaps the negative impact it would have on the more complex investigations that sometimes take a very long period of time. Under our reading of this bill, any property, regardless of whether it's evidence or not, that is seized in some form under any code section, be that the multi-jurisdictional search warrants, subpoena ducus tecums, or even abandoned property, we would have to be both the gatekeepers and timekeepers of that. And that involves every agency working within our jurisdiction, from Game and Inland Fisheries, Virginia State Police, and my jurisdiction would be the Sheriff's Department and the Police Department. And we would have to have individuals in our office tracking each piece of evidence, whether it is abandoned, used in a crime, potentially associated with a seizure, or likewise. And we simply do not have the personnel that allows us to do that. The second key component are these cold cases or these complex cases where we have matters before a multi-jurisdictional task force, or the backup with computer analysis that can sometimes take months and months, or complex litigation, or complex forensics that we're waiting for fingerprints or DNA, and then it goes to fingerprints analysis, and then it goes to ballistic analysis. And those will take perhaps months and months. And to have to disclose in open court what is going on with a piece of substantive evidence during an active investigation would certainly put us at a disadvantage. For those reasons, we oppose this bill.
Mr. Chairman, I have a question. Have you ever had a situation where you didn't actually charge somebody within a year of seizing property?
Mr. Chairman, Senator Edwards, yes, sir. The way it normally comes across in Bedford County, if a citizen has not been charged and they've had some property taken through some sort of investigative action, they call that agency. That agency calls us, and we meet with the investigators or speak to the investigators to see if charges are forthcoming. There is a statute that says if an evidence is not used at trial, it is to be returned to that citizen, and we take that same position.
Right.
If a charge is not forthcoming, we endorse the returning of that property.
But I think one of your
go ahead.
Senior colleagues is behind you who may want to address that. Or maybe he's in line for another bill.
No, for this one, Mr. Chairman, Eric Olson, Commonwealth Attorney in Stafford County. As I understand the bill, the murder weapon in a murder, it belongs to somebody. So it's an unsolved murder. The person that owns that murder weapon could file the petition to get this back. It's ludicrous. Suggesting to me to have the hammer that was used to kill the woman, or the knife, or the gun, or something like that.
Mr. Olson,
yes,
wait just a second. So, I mean, do you have a judge who would say, no, I won't let you keep that for another year? If you went in and said, this is the hammer used to bludgeon the woman to death and we haven't solved the crime?
Mr. Chairman, have to actively file a petition every year to keep that. That's what I understand the amendment. Right now, it's a one-year limit. The amendment, as I understand, suggesting is we could every year keep coming in to having to have that murder weapon.
Mr. Chairman.
It seems to me that the burden it places on law enforcement for such an obvious thing, it should never get returned. There needs to be exceptions carved out for certain type of evidence, and
Mr. Chairman?
I don't see that.
Mr.
Senator
Chairman,
Edwards.
do you have an amendment that flips the burden back to require somebody who, because you already have now a provision that prosecution has the burden of returning seized property under certain circumstances, and that means the person whose property was seized has to go to court and say, I want it back.
All right.
And use that statute and come up with some kind of a
Mr. Chairman,
amendment here.
Senator Edwards, I don't.
Hang on, it's time out. I sense, if I had to take a temperature of the committee, with due respect to to the Commonwealth's attorneys, I sense a desire to maybe report this bill, but accommodate the concerns that Mr. Olson just articulated. And I would suggest that if you don't mind, maybe stepping into the conference room over here. Hey, look, if you can't do it, then
I will
we're
do
gonna do something somebody ain't gonna like.
Well,
Because
I would only say that. all right,
I would strongly urge you to address Mr. Olson's concern, which does sound to me like a reasonable concern that advocates of
Do you want me to
this.
exempt out murder weapons? I mean,
Look, if you don't want to do it, then that's fine.
I'll do it.
All right.
Chap, I'll be glad to talk to you.
These guys would oppose the Bill of Rights. Come on in.
Mr. Chairman, we would not oppose the Bill of Rights.
The Bill of Rights.
All right. Now that we've established that.
Can we leave the door open so we can hear them?
I'm selling tickets.
All right, so next we've got Senator Peake. Why don't you take your fine Senate Bill, I think 343.
Mr. Chairman, members of the
Senator
committee.
Peake moves, Senator Stewart seconds the adoption of the substitute. All in favor signify by saying aye. Aye. All opposed, substitute is before us.
Mr. Chairman, this is the most fine substitute, and I think clears up a lot of the discrepancies we were having, and I think has approval from the School Board Association and BEA, I believe. So we'll see who else is here. But this bill addresses a problem that's actually brought to me originally by Goochland County School Board, where based on a recent Supreme Court decision where people have been convicted of felonies, even though nonviolent and non-bearing on their employment with the school, were unable to maintain employment. It's the case of Butler versus Fairfax County School Board, decided in December of 2015. I think we've cleared it up, and this allows the school board at its discretion to hire somebody who's been convicted of a nonviolent felony not involving children, who's had their rights restored, and the conviction was more than 5 years ago.
Let me put a finer point on this. This is a bill that my Senate Bill 343, I think, has been rolled, or excuse me, my Senate Bill 928 has been rolled into. And this was heard before the Education Committee, I believe.
Yes,
And the
Mr. Chairman.
situation is this. We had great confusion among school divisions in the aftermath of the adoption back in 1993 or 94 of this seeming prohibition on the hiring of felons. Great disagreement or uncertainty as to what authority the school boards had. And we had people around the state who were applying for jobs with school boards who truthfully answered the questions on their application, notifying them that of youthful indiscretions and other offenses, and if they were felonies, the school board in many instances were hiring these people, and the issue was a lot of these, and one I'm familiar with involved somebody who was convicted of involuntary manslaughter after an accident at age 18. and went to college, graduated, got a teaching certificate, was hired by a school division, truthfully answered the application, provided all of the information, was a successful teacher, coach, and in 2017, I guess?
2015.
2015, the Supreme Court issued this opinion saying you can't do it, even though these people were truthfully answering these questions, and that prohibition would have applied to janitors pushing the mop if they'd been convicted of felony larceny for a $200 larceny. And what this does is it still provides the school divisions with that information, but allows them to make the determination. And it has broad prohibitions on the employment of certain categories of felonies, particularly those involving offenses involving children.
Mr. Chairman, I have a substitute to make.
Amendment?
Amendment to make. Line 15. And after child, and we want to keep in, and whether the applicant has been convicted of a crime of moral turpitude. And so they will have to disclose that, but it will not be a bar.
So Senator Peake moves to unstrike the language stricken on lines 15 to 16.
Except for the Roman numeral II or double II.
Got that?
And
Charles?
Yes, Mr. Chairman.
All right, Senator Peake moves, Senator Stewart seconds the motion. All in favor of that amendment signify by saying aye. All opposed? All right, that amendment is made. Anybody wish to, anybody have any questions of the patron? Anybody in the audience wish to speak for or in opposition to the bill? Anybody have a motion? School Boards Association, you're okay with this? Yes, sir. Awesome. All right, it's been moved. Steve, do you have anything you?
Just the same cautionary note I've sounded on 2 other occasions, that each time an additional restriction is placed upon people who have already been convicted and sentenced, it raises the vulnerability to an ex post facto challenge to the regulatory scheme.
My understanding is this removes restrictions and doesn't impose any new restriction.
This allows them to be hired.
This allows people to be hired who were previously not eligible to be hired. Under the previous law, there was a prohibition on any felon being hired by any school board.
Or crime of moral turpitude, even a misdemeanor. So this removes that prohibition.
Okay. All right. Is there a motion? All right. Clerk will open the roll. All right. The substitute as amended is reported. You have another bill?
Thank you, Mr. Chairman. Yes, I have another excellent bill. Senate Bill number 341. And I believe there'll be some people to talk on both sides of this bill, Mr. Chairman, but before we start, I just want to point out, this is a civil asset forfeiture bill. I believe we have heard some of these in the past. This is my first time bringing one. I'm bringing it this year. And I just want to say to the committee and the chairman that no one supports law enforcement more than I do. I have fought for our sheriff's deputies, our state troopers. This is not a law enforcement issue. This is a constitutional issue. And we have to fight for the Constitution. We have to protect our constitutional rights. And nothing is more unconstitutional than taking somebody's property without charging them with a crime and then putting the burden on them to keep their property that was seized. And that's all I have to say at this point.
All right. Anybody have any questions of the patron? All right. Who wants to speak in favor of this good bill?
What you do? You gotta be convicted first.
Again, Mr. Chairman, members of the committee, Susan Lascalette, Virginia Tea Party Federation. One of our main tenets is rule of law. and no one supports law enforcement more than we do. We want them to have the resources that they need to do their jobs. Our response when they say they need more resources is give it to them. We want them to be able to do what they need to do to help protect all of us. But however, as Senator Peake said, we find it objectionable that innocent people could have their property taken. Thank you very much.
All right, thank you.
Mr. Chairman, members of the committee, Steve Rossi with the Family Foundation again.
Yes, sir.
And we support the bill for the same reasons Susan stated, same reasons the senator so eloquently
Thank you.
stated. Thank you.
Yes, sir.
Mr. Chair, members, Bill Farah, ACLU of Virginia. On behalf of our 42,000 members, we support the bill. We're opposed to the government being allowed to seize and forfeit anyone's property without a criminal conviction.
Thank you. All right. Anybody in opposition?
Good afternoon, Mr. Chairman and members of the committee. My name is Lori DiGiacia. I'm a Deputy Commonwealth's Attorney in Stafford County. I'm here on behalf of the Virginia Association of Commonwealth's Attorney. Mr. Nance, who's Bedford's Commonwealth's Attorney, was assigned this particular bill. He is in the back on the other seizure bill. I can speak to a number of the issues. This ties this to a guilty finding in order to have some sort of process. I think the General Assembly is under the impression that there's no process that is done to make sure that there is a connection between the asset forfeiture and the seizure of that property and some criminal conduct, when in fact in Virginia, we do have due process. We do have to go before the courts and prove, in fact, as a matter of fact, about a year ago, I believe it was a year ago, you all passed the legislation to increase the burden from preponderance of the evidence to clear and convincing, which is the highest standard you can have in a civil case. And we still have to come into court and prove that the proceeds are from criminal conduct. And there's due process where witnesses are called. As a matter of fact, in civil cases, there are depositions. There is a full and fair opportunity to see if the property is, in fact, related to the crime. So when we tie it to a guilty finding, there's a couple of things that we have concern about with a criminal process. A lot of the folks that we deal with that are criminals put the property under somebody else's name. It could be grandma, it could be the girlfriend or boyfriend. And so it's not associated necessarily with the criminal conduct. We might be able to charge that person. We generally don't charge those people as someone who's an accessory, like the grandmother or something like that, who bought the car that transported the drugs. So it puts us in an untenable position where we will be having to give back proceeds from drug sales if, in fact, you have to tie it to a criminal conviction. Some of the other concerns are that it can have the appearance of the prosecutor allowing someone to buy their way out of a criminal conviction, because what the appearance would show for folks, it would be that, let's say the drug dealer had $500,000 that we seized, but we have a criminal charge against them, and that we bargain with them in order to have a plea agreement where, in fact, we require them to give us that money, to forfeit that money to the Commonwealth. So it can give the appearance that we're allowing people to buy their way down to a lower conviction or a lower sentence. We try very hard in the training in the Commonwealth through the Commonwealth's attorneys and through state police and the agencies that we hold every year is to do whatever you can to keep those things separate within your office and don't combine the plea agreement with it.
All right, let me just say a couple of things. First of all, two fascinating forfeiture bills, and I hear you loud and clear. I know that we referred this to the Crime Commission in 2015 for the Crime Commission to study. I mean, we're all concerned about the potential for abuse and have all seen some of the stories of abuse. And what the Crime Commission, I think, reported is that while the stories around the country are, in many instances shocking and need to be addressed, fortunately, we're not seeing a lot of those incidents in Virginia. In 2016, we adopted Senator Carrico's bill changing the standard. I think that we're cognizant of the concerns that you and the Commonwealth's attorneys have addressed, but I think we've got some balancing that we need to do. unless there's further discussion, I know that this bill has to go to the Finance Committee. And we'll continue to look at it as
Yes,
it
sir,
works
Mr.
its
Chairman.
way through, if it gets out of here. So Senator Stanley moves, Senator Stewart seconds, the motion be, or that the bill be reported and re-referred to the Committee on Finance. Okay.
Thank
you. You want to do this? Do yours now?
Mr. Chair.
Who's that?
Mr. Chair.
Senator Peterson.
Just
I'm
to
sorry.
follow up, I had a chance to speak with my colleagues, the Commonwealth attorneys, and on 224, I think we're going to have something for you next meeting, which hopefully everyone can get on board with.
Got an agreement in principle?
We're getting there.
In principle?
Yes, sir.
Okay. All right. Well, that's great. So, Senator Stewart, we're not doing all of yours now. Yeah, I guess. You've got a Senator Surville type docket today.
My bills are very simple and quick.
I'm talking about the number.
Oh, just not that many, not that many. Mr. Chairman, could we start with Senate Bill 727?
727.
And, Mr. Chairman, what this bill does is it clarifies that the records and notes, communications between the court staff and judges, including the courts of record and courts not of record, the Office of the Executive Secretary of the Supreme Court, are exempt from the provisions of FOIA, but it directs the Supreme Court to develop rules of court to clarify the process for accessing those public records in their custody. And I'll tell you all, I'm not trying to keep this information hidden, but I believe in the doctrine of separation of powers. And the Supreme Court is a co-equal branch of government. I have absolute faith in them that they will develop a rule that will allow for the public inspection of what should be inspected. They understand the intricacies of the court, frankly, better than the General Assembly does. And right now, the law is just not clear.
Mr. Chairman.
And this clarifies it. It gives them direction to develop that rule and enact a rule. And I hate to say this, but if we don't like the rule, we can always come back and act later.
Mr. Chairman, what is the problem? that needs to be
Senator
solved?
Edwards.
There are a lot of bills to deal with this issue. Mine is specific to one point, but it's not clear what exactly the public is entitled to.
Mr. Chairman, can you give me a specific example of what's not clear?
Well, if it was clear, I could give you a specific example. No, that's why I can't, because it's not clear.
Well, Mr. Chairman, is the Supreme Court asking this? And if so, are they here to?
I think the Supreme Court is okay with this.
Well, I'd like to have some kind of example of what the problem is, because I didn't know there was a problem. Maybe the Supreme Court's here.
Well, I mean, Senator Edwards, this goes beyond what now.
Yeah.
All right, I'll step aside.
Yeah.
All right. Let's hear from the court.
Mr. Chairman, members of the committee, Christy Wright, OES. There is confusion about communications between justices, judges, court staff, and judges. It is unclear because I think a lot of the public thinks that the code is the only law that is in Virginia without really understanding that there's case law, that there's common law. And so if we say that record is not public, there is confusion regarding that because they say, well, show me a place in the code where it says I can't have that record. And as we know, communications among judges or justices or with staff, say a law clerk does a memo for a judge to assist in his or her deliberation, that is something that would not be made public. Of course, the final order in a case would be made public. And so this rule and what this is intended is not to address those records that are currently in the case files maintained by the clerks, which is open and public. It is those other records.
Let me ask you, Mr. Chairman, is the Supreme Court subject under the code to the FOA? I don't know whether they were or not. I never heard that they were, but maybe they are. I mean, are they currently subject to FOIA?
I'm sorry, are you asking?
Yes.
Well, every Chief Justice in Virginia since FOIA was enacted has taken the position that it does not apply to the
Okay.
judiciary.
All right.
And again, like I said, I think this addition is necessary. It's helpful to the public because it provides that reference within there to say that it is,
Well, Mr.
it makes
Chairman,
it clear. And plus, it also then gives a reference to where they could find in the rule what would be open and the process to access those records.
Mr. Chairman, it sounds like, and
Sarah
correct me if I'm
Edwards.
wrong, it's a matter of clarifying for the public, but can't the Supreme Court do that on its own? Why do we need legislation?
Yes, it can now.
Yeah, so
It
why do we
can
need?
now, if we clearly exempt them from FOIA and direct them to establish the rules governing the inspection of this
Mr.
information.
Chairman, as I understand it, they're not subject to FOIA right now.
All right.
Someone
Is
would
that-
disagree with that. I
well-
think we
There-
would say
there-
that, but others would disagree.
Oh, is that a question, is whether or not they are subject to FOIA?
Well, as I said, every Chief Justice
Yeah.
since FOIA was established had said that the
Yeah.
judiciary was excluded. But I think there is a lack of understanding. It is not clear. And because it also gets into questions of common law.
I understand
And,
that, but
yeah,
Mr. Chairman, can't the Supreme Court clarify it in its own website or something as to what's? I mean, it seems to me it's just a matter of Supreme Court communicating to the public
That's what we're asking them to do, Senator.
Well, can't they do it on their own? I guess that's what I'm asking.
Well, and I think typically that is something that the legal question has not been before the court, and that's how the court would speak. And in this case, the Constitution provides that the Chief Justice is the head of the judiciary, and it makes it appropriate for the court in that case to promulgate the rules. But as far as that legal determination, there has not been that case before the court.
I think what this would do, and whether you like it or not is another question, but what this does is makes a policy statement as to whether the legislature is taking the position that the Supreme Court is covered by or not the Freedom of Information Act. When Congress adopted the Freedom of Information Act federally, it expressly did not cover the judiciary. And the federal judiciary has adopted pretty expansive open records rules or guidelines that it follows. And I've read with interest the Virginia Supreme Court statement last week concerning some broad policy statements about the direction that at least I took as to the direction that it's likely to take. So anybody have any other questions of Senator Stewart? If not, let's hear from people who want to speak in favor of or in opposition.
Is the Supreme Court expressly asking for this?
I have worked with the Supreme Court on this bill.
He's vice chair.
What'd they say?
All right, anybody wish to speak in opposition to this? Well, good afternoon.
Thank you, Mr. Chairman, members of the committee. Megan Ryan with Virginia Coalition for Open Government. And I just want to start by saying that I'm grateful to the OES for sitting down with me to listen to my concerns. As I affirm to them, and I want to affirm to this committee, my objection to this bill is not because I think that the senator is trying to shut the door on access, and it's not because I doubt the word of the Supreme Court as it was expressed in its press release last week. So please want to be very clear on that. My objection is primarily one of timing, whereas I believe that this bill puts the cart before the horse. Instead of taking the judiciary out of FOIA and then directing that the rules be written, I would suggest that the rules be written and then you can take the judiciary out of FOIA for that clarity that is sought, if that is the decision that is going to be made. I believe it would be more protective of the citizens' right to know excuse me, the citizens' right to know, to have those rules and procedures for accessing all types of court records that are in place before the courts are then taken out. Because to be clear, we're not just talking about court case records. We're talking about records that also have to do with the performance of the court, statistics, reports, evaluations, and we're also talking about records of the courts as another government agency that is supported by taxpayer dollars, and that the citizens would like to know how much money is being spent on things, how much money is coming in for various transactions. And if, I don't know if it's a possible compromise. I am totally sympathetic to this notion about judicial communications being, worrying about the status of those. And if that could be, if that was the provision of the bill saying judges and their communications with law staff is exempt from FOIA completely, that it would give me far less heartburn. But taking the judiciary out without having rules in place causes me great concern. Thank you.
Thank you. Appreciate that. Yes, ma'am.
Good afternoon, Mr. Chairman, members of the committee. Amy Perrin-Seibert on behalf of the Virginia Press Association. And to be clear, we don't actually have a position against this bill. We're sort of in a neutral posture, but we were here today to ask the General Assembly to encourage the court to be as open as possible with the rulemaking process. We really think it's important that process be transparent, that the public is able to participate. But we are also, as Megan said, very sympathetic to the ideas of judicial documents being kept confidential. So I think we just want to make sure that that process is open, and we'd like the General Assembly to encourage them to do that.
Okay.
So thank you. Appreciate it.
All right. Anybody else in opposition? All right, the bill is before us.
Mr. Chair, could I just, if I could, I find myself in agreement. I'm troubled by this whole topic. I would much prefer to have a bill before us that said these sort of documents, these sorts of communications are exempt from FOIA, rather than us saying that a branch of government is exempt from FOIA, and that's what we're saying. I have a great deal of heartburn with that. The taxpayers, after all, pay for all three branches, and they're entitled to certain information. I just wanted to explain what's behind my
I think
vote.
we just have to trust that the court's going to adopt
Miss-
the right rules. And for instance, there are already some things that are exempt from FOIA, but the court provides all that information, and a lot of it they provide online.
But Mr.
And
Chair,
not required to.
Mr. Chair, Senator Stewart, that's my very problem. I mean, there are voters and taxpayers out there that don't want to hear from any branch, any part of government, trust us, we're going to do the right thing. Because, unlike legislators, we operate in public. If more than a quorum is present, it's a public meeting. With the court, so much of what the court does is veiled behind the robe, and it should be. But in my view, we'd be better off if we had a bill that set forth specifically what's exempt from FOIA, and let the chips fall where they may from there.
Mr. Chairman? Mr. Chairman.
Senator Edwards.
I tend to agree with Senator Deeds. I mean, I don't see what the problem is. I think we got the cart before the horse. I don't think we ought to just broadly exempt the Supreme Court or anybody else. I mean, obviously, I'm well aware of, judicial confidences and all the rest. I had never thought about whether the Supreme Court was exempt or not. Apparently, the Supreme Court takes a position it is exempt. It may well be, and it probably should be for the most part. But I'd like to see if the Supreme Court thinks there's a problem, come up and see what their rulemaking would be, what they propose as to what should be exempt and what shouldn't be exempt before we give a blanket exemption. I mean, I don't think the public will understand doing this. I can't, in other words, I'm having trouble figuring out what the problem is that we need to fix.
Well, Mr. Chairman, Senator Edwards, if this bill passes, hopefully they'll do that quickly.
But they can do it already.
Let me ask, and this may be unfair to the patron, but let me ask counsel, Kristen, do we, by some miracle, happen to have another bill addressing similar subjects that might address some of the concerns that have been expressed that maybe Senator Stewart's bill could be incorporated into?
We do, Mr. Chairman. It's your bill, Senate Bill 564.
You may want to turn that microphone on so that everybody can hear you.
Senate Bill 564, Mr. Chairman, it actually lays out the process by which people can request records, how the courts will disclose those records. It requires the Office of the Executive Secretary to make publicly available online case information system for criminal cases. So a lot of the questions that people have been asking about what the process will be that the court comes up with are answered in your bill.
And Senator Stewart's language, in its essentially the substance of his language can be incorporated into this without doing violence to Senator Stewart's goal.
Yes, Mr. Chairman, your bill also has an exemption in it, and we could use, instead of your exempted language, we could use Senator Stewart's.
And if we do so, can we do it under Senator Stewart's bill number?
Yes, we can, Mr.
We're going to do it under the chairman's bill number.
Can we, Mr. Chairman, can we roll one bill into the other?
Mr. Chairman, I've suffered enough editorials across the state. I want you to get a few.
Let me.
Assuming that happens, what language from Senator Stewart's bill would be put in your bill? That's
Counsel.
It would be the language on lines 37 through 38. The judiciary, including courts of records as defined in 1-212, courts not of record as defined in 16.1-69.5, and the Office of the Executive Secretary of the Supreme Court.
In all fairness, Mr. Chairman, we ought to hear probably from the open government folks in the Supreme Court on that.
And the clerks as well. All right. Supreme Court have any comment upon that?
Mr. Chairman, no, we would not oppose that.
All right. Mr. Dix.
The clerks would not have any problem with that.
And let me ask the FOIA counsel, does this address some of your concerns? I don't pretend to suggest that it addresses all.
It's not the FOIA counsel.
I'm sorry. I know.
From Open Government.
I'm sorry.
I'm sorry, Mr. Chairman. Coalition for Open Government. I just am not familiar enough with the provisions of the bill to be able to comment.
Okay.
But
all right. So it's not going to make you like it any less. I doubt.
Mr. Chair.
Fair enough. Senator Deeds.
I apologize. I'm not as familiar with the terms of your bill either. But does this bill specifically say which things are exempt from FOIA, or does it basically you're just incorporating the same rulemaking authority that Senator Stewart?
Well, Senator Stewart, the guts of Senator Stewart's language on lines 37 through 40 would be incorporated in, and Senate Bill 564 defines other information that shall be provided.
Okay.
Is there a motion to that effect? To roll those together into Senate Bill 727. All right, it's been moved and seconded to roll the bills together in the manner described by counsel.
And report?
And Senator Mason's bill.
And report?
And to report.
I'll second that.
Where's Senator Mason's bill?
That 519?
All right, before we make a mistake, let's get the...
Mr. Chairman, the Supreme Court does indicate that there may be a fiscal impact, so this probably has to go to finance, even though it's not showing up on Department of Planning budget yet.
All right. So, Chip?
It's your bill, not mine. Your bill has the fiscal impact, not mine.
So
Mr. Chairman, I know that on 564, the way it is in the substitute, we have broad consensus on that bill among all the various different stakeholders, and we've worked 6 or 8 months to get there. So if adding Senator Stewart's piece causes problems, then I would reluctantly say that maybe it ought to be a separate standalone bill.
All right, let's do this. Rather than unduly complicate it, here's what I would recommend. Let's take up Senator Stewart's bill. Kristen, you have an amendment that would take these two out of conflict, and if for some reason my bill does not advance, then Senator Stewart can add this back in on the floor. Okay?
Mr. Chairman, you would delete on line 38, access through on line 40, Virginia, and you would delete the second enactment clause.
Delete the second enactment clause. Okay? Is there a motion to adopt those amendments, Senator Stewart?
So moved.
It's been moved and seconded. All in favor of those amendments signify by saying aye. Aye. All opposed? All right, those amendments are made. The bill is before the committee. Is there a motion to report the Senate Bill 727 is amended?
Move to report as amended.
Is there a second? It's been moved and seconded. Clerk will open the roll.
Ayes 10, noes 5.
All right, the bill is reported.
Thank you, Mr. Chairman, members of the committee.
All right.
Mr. Chairman, I do have a witness here, someone to testify for Senate Bill 952.
All right, and that one is going to have to go to finance if it reports out.
Yes, Mr. Chairman, in the very simplest terms, and I'm going to let Eric speak to it a little more. What this does, you all know now that when a court grants a protective order, it can be for 2 years. Well, there are certain crimes where, frankly, that protective order should be in place for a lot longer. And what happens is that victim or the person who's being protected has to keep coming back to court, and it's unfair to them. It's not judicially economical. And so what this bill would do is it would just give the court the discretion under certain circumstances to extend that, well, not extend, but to grant that protective order for an indefinite period of time. Now, again, and that may scare some folks up there, but we give judges discretion that, I mean, frankly, have huge impact on people's lives, and we trust them to do that, and that's what their job is. And this is just one more element of that. And I think it's an important thing. You think about the trauma that somebody who's been victimized having to go through when they have to come back in and ask for this protection every 2 years when they could have been, you know, a victim of attempted murder and barely escaped. So, I mean, we try to weigh the balance of the competing interests, and I think this is a reasonable approach, and it puts it in the judge's hand. Eric is here somewhere, and I
Mr.
know would
Olson.
like to speak to this. Come on up, Eric.
All right, those who wish to speak in favor.
Mr. Chairman, Eric Olson. I'm the Commonwealth Attorney in Stafford County. It was a case of mine from a number of years ago that made me start thinking about this. It was an abduction and a malicious wounding case, and the defendant ended up getting 7 years in the state penitentiary. It was a terrible domestic violence case, incredible controlling individual. Every 2 years, my victim, Trish Jackson, had to go to try to re-up a protective order. It was obvious at the time of sentencing that she needed to be protected for the rest of her life from him. But the circuit court judge didn't have the power at sentencing to make that happen. He can enter an order saying no contact and make it a condition of a suspended sentence. But the problem with doing that is if there's a violation, the law enforcement doesn't get involved. The Commonwealth's Attorney's Office is required to bring the petition, and there's a huge timing gap. So if I could, I'd like to call Trish Jackson up, and she can tell you just briefly her story and some of the things that she's had to go through in order to get this protective order year after year. Trish, come on up.
Well, Well, thank you, Mr. Olson. Thank you and welcome.
Thank you. Good afternoon, Mr. Chairman and members of the committee. My name is Patricia Chris Jackson, and I'm a citizen with a protective order due to domestic violence. And after 15 years of emotional and verbal abuse, my husband started physically abusing me. He started choking me, shoving me, hitting me, and throwing things at me. And when he started to say, "I'm going to kill you," I knew I was in deep trouble. I was a mess from the abuse so bad that I didn't know that he was also abusing our son. He kept threatening to kill me, and after a while, my son left the house. And at one point, he assaulted our son in front of me, and that's when I left him and stayed with friends. During that 6 weeks of separation, he stalked me, harassed me, and damaged my vehicle. He eventually agreed to a divorce, and we agreed to meet to sell the marital home. I went to the marital home, and the realtor wasn't there. I went inside, and that's when he attacked me. He dragged me down the hallway and said, "I'm going to finish this once and for all," and attempted to throw me down the basement stairs. I tried to get his grip off of me, and at that point, I escaped and got to the back door, tried to unlock it. He grabbed me from the rear, threw me over the couch onto the lamp table, and was on me in a second, choking me. I was able to get away from him, climb back over the couch, get to the back door again, and the dog, when I opened the door, the dog came in, and my husband was able to grab me and pick me up and throw me down the stairs, attempting to kill me. I landed, hit the wall, and I hit every stair on the way down. And when I got to the bottom, I was still alive. So he headed down the stairs, fist back, ready to finish me. That was his plan. He told me we're going to finish this now. After many attempts to get him to get out of the basement, because he stopped hitting me, I was at the bottom of the stairs, and I said, "Let's go upstairs." And eventually I talked my way into the house, then out into the backyard, and then into the front yard. And I told him that I would leave, but I would come back, that I didn't want a divorce. And I talked my way out of further assault. And when he let me leave, I got in my car. I was in total shock. I drove to Fort Belvoir Hospital. My husband was a retired Marine Corps officer. So I went to Fort Belvoir, and the emergency room technician told me I have to call the sheriff's office. And I said, "Please do, because I haven't been able to." And a sheriff's deputy actually showed up at the hospital that night after I was admitted. And he gave me an emergency protective order and told me I needed to be in court the next day for another protective order. I left the hospital, went to the courthouse, and was issued another protective order. And thanks to the Commonwealth Attorney's Office, I got a temporary protective order, and my husband was charged with malicious wounding and abduction and faced up to 30 years in prison. I had no idea what was ahead of me in court, and I knew that he couldn't get away with his crimes anymore. In January 2005, a jury convicted him of malicious wounding and abduction, and he received an 8-year sentence. He also later pleaded guilty to assaulting our son, which he did in front of me, and that was the impetus for me to leave the house. And since he kept firing his attorneys while he was locked up, I had to face him in court, and he could question me. And it was horrible. And eventually, my divorce attorney quit, and I had to be my own attorney and face him in court, and he was able to harass me. And while he was in prison, he had private eyes on me and his friend stalking me. So I had no protection. And during his entire incarceration, he kept me in prison of my own with all the court appearances, harassment, and extreme financial stress. I had been in court over 50 times between the criminal case and the divorce. And not a day goes by that I don't fear for my life. And I think every victim feels this way. Once you're victimized, even though you survive, this goes through your head every day.
Thank you.
And I get in my car, and I think he's going to be there, and he's just going to kill me. So I will continue to appear every 2 years for a new protective order. Mine currently expires November 16th at 11:59 p.m., so I will go back to court. I've been very lucky that the judges currently know my case, know how severe it was, but in the future, I may get a judge that doesn't know, and I may not be granted this, and that gives him in his mind, knowing his mind, he has the ability to come down and come after me and our son and grandkids, and I'm very worried about that. So, victims going to court, they have a very hard time just going to court. Think of how many people don't even report crimes. Just to go to court and do that, but to go back every 2 years to get another protective order is just cruel. And I hope that you understand. Thank you.
Well, before you leave, let me just say, I know it's difficult to come and tell that story. It's a very compelling story. I'm sorry for what you're having to endure. I'm glad you've got Mr. Olson and his office to support your efforts and protect your rights as a victim. So thank you for being here and for sharing that. So thank you. Anybody have any questions of the
Yes,
patron?
Mr. Chairman.
Senator Peake.
Senator Stewart, and I understand what you're trying to do here, and that's a horrible story, and I'm sympathetic. But there's just no way I can vote at this time to give a lifetime protective order, knowing what I've seen in other cases. And is there been any other consideration as to different time periods?
Well, this would give the court the ability to issue one up to. But, I mean, I guess you could assume that they're going to do that. And in some cases, they should. But in others, I don't suspect they would. Again, we trust our judges with an awesome amount of discretion in so many other areas. This is just, we can't trust judges to make this determination. I'm not sure they should be sitting on the bench.
Thank you. Anybody wish to speak? Else wish to speak in favor of the bill?
Thank you, Mr. Chair. Sushila Varki from Virginia Poverty Law Center.
And
We
if-
support the bill. And I just wanted to speak to Senator Peake's comment. It's under the discretion of the judge to issue the order for as long as they wish. It doesn't have to be lifetime. It could be 3 years.
Right.
But the point is that it can be re-traumatizing to petitioners to keep coming back. Not to mention, as Eric Olson mentioned, I think sometimes people say, why is this necessary if there's a no contact provision that's going to accompany the criminal conviction? The reason this is necessary is because a protective order violation can be pursued by a petitioner or law enforcement, whereas the no contact violation can only be pursued by the Commonwealth's attorney.
Okay.
And Mr. Chairman, that's an important point that I neglected to bring up. Under a no contact order, you've got to bring a show cause, and you've got to try to get that defendant back, get him served, and get him back into court. If they violate a protective order, the deputy can arrest him on the spot, right? And that's a lot of protection to somebody that is being stalked and that they've been threatened to be killed. It's a big deal, and so that's the biggest protection out of all of this for them.
Well, let me ask Steve, and I'll tell you, I have great sympathy, and we had, I know the consequences of serial violations of protective orders. I know the challenges that exist. But here's this question: I guess it's possible under this bill for somebody to have been convicted for the crime that they were accused of, to have served their time, for all suspended time to have been served, for there to be no continuing obligations, and yet a person could still be under the terms of a protective order issued pursuant to this. And maybe Mr. Olson would say, yeah, and that's one of the benefits of this protective order, is because it kept the person from reoffending. But then, if there is some contact, can that person face serious consequences years after years of good behavior, and maybe for a technical violation? Steve?
Yes.
All right.
Mr. Chairman, if I may, I would suggest, in my experience, judges will issue the protective order for the length that they would normally order the no contact. And that would depend on the nature and circumstances of the offense. A serious offense, I've seen judges order no contact for the life of the victim, but those have been rare. In my almost 30 years, I've seen it probably 3 or 4 times I've seen that. You know, you're going to have a period of suspended sentence, and many times you can have a no contact order. This just gives the sentencing judge the ability to put a protective order behind it. That allows the victim to call the police if there's a violation. That allows the police to intervene, and it saves the victim after just 2 years of having to get that protection time and time again, if the judge in his or her discretion feels that that's appropriate. I don't think it's, another way to say it, I don't think it's a concern that judges will be putting lifetime protective orders in cases that most people wouldn't agree that would be appropriate.
Okay. All right, any other questions? Bills before us.
Move the bill be reported. Second.
It's been moved and seconded the bill be reported and re-referred to
This
finance.
would have to go to finance, I suspect.
All right. Clerk will open the roll.
Ayes 14, noes 1.
All right. Thank you.
Thank you, Mr. Chairman.
Next bill faster.
Next bill faster, Senate Bill 939. Why don't you drink a Coke or something? Stanley? Mr. Chairman.
All right, this bill is identical or very similar to bill that you had last year, passed out of courts 11-1, out of Senate 38-2.
But there need to be some amendments to make it identical, which I actually would move if Kristen has them. If they don't, the Supreme Court might, or if we could conform it.
All right, so you want to move to conform to Senate Bill 879 from last year?
Yes, Mr. Chairman.
All right, is there a second? All in favor of conforming to amending to conform to Senate Bill 879 from last year, signify by saying aye.
Aye.
All opposed? All right.
And Mr. Chairman, we qualify all the judges before they are elected in the Commonwealth. This would also require us to qualify the judges that are sitting as substitutes after they retire every 3 years so that they can be on the callback list for the Supreme Court. It did pass the Senate overwhelmingly last year. I ran into a little bit of trouble in the House. And the amendments that were put on it that we conformed it to were at the request of the Supreme Court, so there's a delayed enactment clause.
You want to delay until July 1, 2019?
2019 is
All
what it should
right,
be, Mr.
Senator
Chairman.
Stewart moves that amendment, seconded by Senator Reeves. All in favor of that amendment, signify by saying aye.
Aye.
All opposed, that amendment's made. Anybody wish to speak in favor of this bill or in opposition to the bill? Bill is before us. It's been moved and seconded. The bill as amended be reported. Clerk will open the roll.
Ayes 14, noes 1.
All right. Next.
Mr. Chairman, Senate Bill 339. This is also a bill that actually I carried, and it passed the Senate overwhelmingly in 2014 and ran into some trouble in the House. But it is such a worthy cause, Mr. Chairman, that I brought it back. And what it would allow is for the court to take a case under advisement if the defendant had an intellectual disability or were on the autistic spectrum. And some may balk at that, I'll tell you, and it can't be a violent act. But the reality of this thing is, Mr. Chairman, particularly people on the autistic spectrum, they do not perceive things the way most people do. And so a young adult, not even a child, but a 25-year-old.
Richard, I think that unless there's been a change of heart, this committee passed this out 14-1 in 2014. I don't mean to short circuit you, but
sir.
I think, Kristen, do you have a suggestion, or Charles, for an amendment on line 124.
I don't think he did, Mr. Chairman. I think he likes the bill the way it is.
Okay.
We had a change, I'm just trying to understand my notes.
I'm sure we'll be able to strike and amend things on the House side, even if it even gets a hearing.
Yes, Mr. Chairman, there were two amendments. One was on line 124, after section 19.2, 297.1, was insert "or any crime for which deferred disposition is provided for by statute." And then the second amendment was to strike lines 141 to 143.
Those okay with you, Senator Stewart?
Yes, sir.
All right, you move those amendments?
So moved.
It's been moved and seconded. All in favor of adopting those amendments signify by saying aye.
Aye.
All opposed? All right, those amendments are made. Bills before us.
Move to report as amended.
All right, and I'm sorry, don't know whether I asked whether anybody wishes to speak for or in opposition to the bill. I don't think so.
Look, they won't
Okay.
speak against it. That's good.
All right, it's been moved and seconded the bill be reported. Clerk will open the roll.
Ayes 14, noes 1.
All right.
Mr. Chairman, Senate Bill 308. And this is a little bit of a heavier lift. So most of you all who are lawyers that practice in the lower courts anyway know that 2 years ago there was a case called Commonwealth versus Seraphin, or Seraphin versus Commonwealth. And essentially, I'm not going to go into the holding of the case, but essentially what that case says is we can get a DUI on our private property. And so the ultimate, and I'm not criticizing the Supreme Court for this, they're interpreting the law as they see it that we have put on the books. What that extrapolates out to is I can be on my lawnmower in my yard in plain view from the highway if I'm drinking a beer cutting my grass, which I really don't do. But if I did, they could stop me and charge me with DUI if the facts were sufficient. If you're on a tractor, if you were on a golf course, I mean, if you were minding your own business, but you had a drink on a motor vehicle on private property, you are subject to this. Now, and people say, oh gosh, are the officers really charging this?
Yeah.
I am aware of a case right now where a kid, 25 years old, was cutting donuts in his field, about a half a mile off the road. A half a mile off the road. Well, the officer saw a dust cloud, stops, walks past a posted sign, stops the kid out in the field and says, "Are you drinking?" He said, "Yes, sir. Been drinking all day." And he said, "Well,
What is he charged with, stupidity?
well, no, because that's legal in Virginia, Senator Edwards. No, he got a DUI from that, and he wasn't close to the road, and it's being prosecuted. And so what this bill does, and it probably needs an amendment, even if you all will entertain me on this bill, but it just says driving on the highway is defined in 46.2-100. If you look at 46 point, which I think is what the legislature always intended, 46.2-100 means all of the ways in between the roadways. It is areas enacted by a statute, by the locality. It may not include a parking lot at Walmart. I think it does include the roads and ways at Busch Gardens under 46.2-100. I absolutely do. And so I welcome an amendment. I've tried to figure this thing out. I really have tried to figure this thing out.
So it's work in progress.
It is, but look, here's the reality of it, and this is where my friend and I, Attorney General Ken Cuccinelli, agree.
You are better off to let a few people off to protect the rights of law-abiding citizens. And that's what this does. I have no business being arrested for DUI on my private property unless I'm out in public threatening to injure somebody. I should be able to be as stupid as I want to be on my private property.
So-
I should be able to be as stupid as Bill Stanley is on my own private property.
So the amendment that you're suggesting is to limit this to your property?
No, sir. No. I want to protect people on their own private property.
Yeah,
And
that's what I mean.
And the
On-
issue is, I don't think you can do it that way, though. I don't think you can write it that way. I think you've got to come at it from the other way. And I think 46.2-100 defines a great deal of it.
Right.
And then, actually, what I had considered was if you included in this definition any other area designated by a locality for public use. And so it may be a little bit of a chore, but I think the owner of Food Line could go to the county and say, we want this included under the ordinance. And so you sort of have a Christmas tree ordinance where these things are susceptible of people being stopped for DUI by the police. It's a little bit complicated, I get it. But we've got to protect people on their private property.
You offering that amendment?
Well, no, I'm throwing it out, and
Mr.
Mr.
Chairman,
Benjamin's
yeah.
thinking
Sarah
about it.
Yeah, if there's a way to, you don't want people riding on in shopping centers drunk.
No, I agree.
And-
I agree. I
and
just
if there's a
haven't
way to
figured out how to
define
do
it. On the other hand, if you're out in the hayfields, that may be different. I don't know how you define it, though.
All right, let's hear from those who wish to speak in favor, those who wish to speak in opposition.
Commonwealth Attorney's going to abandon it.
Nathan Green, Commonwealth Attorney for the City of Williamsburg, James City
We
County.
want Mr. Olson up here to talk about.
Speaking on behalf of the Virginia
donut
Association
case.
of Commonwealth Attorneys. Your Honor, Mr. Chairman, this would create a situation in Busch Gardens where a citizen shows up at Busch Gardens, goes in there, drinks too much, and as they're walking back through the parking lot, they could be stopped for drunk in public, arrested for drunk in public, but if they can get to their car and start driving, they're safe.
Well, wait a second. I thought Senator Stewart just said that that the parking lot at Busch Gardens would be covered.
It is not. The Kim case, which just came out earlier this year in 2017, greatly reduced the areas in which the Commonwealth could successfully argue that these parking lots, because they were open to the public, were roadways or highways. That case changed our abilities to argue parking lots like Walmart, Target, any of those locations, where at one time we could sometimes successfully argue that because they were open to the public and because they were not being restricted.
Can you, like Senator Stewart suggested, designate those under 46.2-100?
I have not heard anything. I am not familiar with that ability. I do not believe that Busch Gardens can go to James City County and say, we would like this to be a public property for the purposes of enforcing traffic infractions, but private property for the purposes of maintaining it and doing all those things. I'm not familiar with that ability.
Thank you. Yes, sir.
I'm Kurt Erickson again with the Washington Regional Alcohol Program, a Virginia nonprofit, but also here for AAA Mid-Atlantic and MAD Virginia, all opposing this. You've already heard the analogies of the grocery store parking lots, the shopping center parking lots, the apartment parking lots, which was identified in the Kim case that the state's attorney just mentioned as being of issue. Those are the broad spectrum, but I think if you really drill down to our opposition, it's really the fact that this bill seems to grease an already slippery slope of bifurcating Virginia's DUI laws, which otherwise would communicate that it's okay to drive drunk here, but not there, and for that reason, we're opposed. Thank you.
All right, thank you very much. All right, the bill is before us.
Oh, come on. It's a good bill.
Is there a second? It's been moved and seconded to pass the bill by indefinitely.
Second.
It's been moved and seconded. Substitute motions before us. Clerk will open the roll on the substitute motion.
Don't drink on your own property.
Hang on, don't close the roll. Hang on. Can you clear the roll? All right. This is motion to report. Okay.
quite get there.
Yeah, go ahead.
Ayes 5, noes 7.
Thank you, Mr. Chairman. It didn't report, I get it. I'll keep trying.
You have 339? You have 339? Huh? Flip it. Huh? Okay, never mind, sorry. Okay. Senator Stanley?
Thank you, Mr. Chairman.
One bill, 180.
Senate Bill 180 is a very simple bill. Mr. Chairman, this bill's recommendation comes from the Judicial Council of Virginia. Right now, we have in civil cases, in circuit court, electronic versions of documents that are approved for filing in electronic form by the rules of the Supreme Court have the same acceptability in court admissibility as the originals do. But that only applies in civil cases, and it does not apply in criminal cases, resulting in certain judges in certain cases being reluctant to accept printed copies of digitized documents as the originals in the criminal cases during court proceedings, and thereby requiring the clerk to produce a copy from the original paper document. We have clerks that no longer maintain paper files pursuant to the new code 17.1213, and so they're finding this practice of maintaining certain documents in paper format unnecessary and inefficient. So this bill corrects that by allowing that in criminal cases in a circuit court, electronic versions of documents have the same acceptability and admissibility as originals. And that's the bill, Mr. Chairman.
All right, anybody have any questions of the patron? Anybody wish to speak, feel compelled to speak in favor of the bill or in opposition to the bill? All right, the bill's before us. It's been moved and seconded the bill be reported. Clerk will open the roll.
Ayes 15, no 0.
All right. And next we've got Reeves and my bills. Have one of yours? Senator Howell. Yes, ma'am. 827.
Thank you, Mr. Chairman. 827 is a bill we have seen before and passed. Unfortunately, it didn't do so well in the House. But what this does is allow localities to increase the fee for courtroom and courthouse security by up to $10. In other words, for up to a total of $20. Nothing has been changed. Our last increase was in 2007. And the need for additional courtroom security has increased dramatically. It's, as I said, local option. The governing board is the one that will make the determination of what the amount is, anything from $0 up to $20.
And Senator Howell, I don't know whether you want to answer this or let others
I have a lifeline.
let others behind you, but before you step aside, just let me just say, you know, over the last couple of years, we've spent a lot of time, a lot of energy. The Supreme Court spent a lot of time and energy talking about court costs and fines and fees and the impact that they have on people and the burdens that they place them under and the trying to do everything we can to relieve people of some of those burdens and to suspend some of those challenges. And I know what you're trying to do. I know who you're trying to help, and Lord knows I want to try and help them. But this seems to do exactly what we've been trying to back away from and to add additional burdens. And if you want to just punt to the Sheriff's Association, that would be fine.
I always like to punt to them, but in this case, I think we can go on parallel tracks. We can do more to assist people who can't pay their fees, and at the same time, for those who can, we can do some optional things that are permitted under here.
So this wouldn't be a fee, it would be a tax. Because
it would be a court cost.
Well, because it would be a progressive one at that, in that we would just level it on the basis of ability to pay.
I'm saying that could be open to the various localities.
That's fine. Anybody wish to speak in favor?
Mr. Chairman, I'm John Jones of the Sheriffs, and this is the third time this bill has been here and passed, if it passes at this time. It was raised last in 2007 when it went from $5 to $10. The money is for, a lot of this comes from traffic. So when you're talking about people unable to pay, you're talking about folks on the interstate and get speeding tickets, and a lot of those folks can pay. It is optional. The locality doesn't have to impose the fee.
So any of your sheriffs in localities that are going to come out against imposing that fee?
I don't think they will. I think they'll be in favor.
I think they're going to be
Yeah.
pretty universal.
So it's at $10. The current situation with the compensation board is that we are 124 court services deputies short currently, and that's $4.3 million. And the compensation board only funds deputies in the courtroom. They don't help the sheriff in the locality fund the deputies on the entrances and the magnetometers. There's a lot of other expense, and it's used exclusively for court services. It can't be used for anything else.
You know, notwithstanding my questions before, this came out of this committee 2 years ago on a 10-5 positive vote. So, you know,
Mr. Chairman.
We'll see.
Mr. Chairman, I have a question. What assurances are there the localities are going to apply it to courthouse security?
It's in the.
I know it says so, but you can't
It's
really.
It's in here that it can only be used.
I know it says
And
that.
sheriffs
but
always, you know, they call and they say,
You're not doing it.
I feel comfortable that it is being used for that.
And Mr. Chairman, isn't it true that courthouse security, like law enforcement generally, should come out of the general fund?
I mean, it's fungible dollars.
Yeah.
Okay.
That's where it ought to come, not by assessing people a fee just for having access to the courts in one way or the other.
Don't worry, you're not losing him. You didn't have him before.
That's a rhetorical question. Isn't that true?
Mr. Chairman, Senator Edwards is exactly right. Hunter Andrews is somewhere rolling over because we're funding services, funding general services out of court fees, but we don't have any choice.
All right.
So for that reason, I move to report.
Well, let's hear from, you wish to speak in favor?
Yes.
Yes, ma'am.
Mr. Chairman, members of the committee, I'm Kakilar Vieira on behalf of the Virginia Association of Counties. We support this bill and appreciate allowing localities to have a greater ability to secure their courtrooms and courthouses.
Well, thank you. All right, anybody wish to speak in opposition to the bill? All right, Senator Deeds has moved to report. Senator House, and we refer to the Committee on Finance.
Oh, it does.
And Senator House seconds. Clerk will open the roll. Don't close it yet. Let me figure this out. All right, now you can close the roll.
Ayes 11, noes 4.
You picked up one.
Thank you.
Congratulations. All right, next we have Senator Reeves. Senate Bill 463.
Mr. Chairman, Senate Bill 463, what it does, if I can just have a few minutes, I know everybody's tired. One of the things I'm trying to address, and I mentioned it to some folks, is the heroin epidemic that we have and the ability to have addiction recovery in our ADCs that are run by not our regional jails, but at least those jails that are run by our constitutional sheriffs that do that. And trying to find money has been very, very difficult. So what this bill does is it takes 20% of drug asset seizure monies and specifically reallocate that over to the Drug Offender Assessment and Treatment Fund. I have a companion bill that's a constitutional amendment that helps set this up as well, but that won't be heard until next year. I've talked to the Sheriff's Association because some of the sheriffs, like Sheriff Carl Leonard in Chesterfield, is running these programs now and trying to deal with how do we replicate what is actually working and do that. I'm working with the administration as well because the challenge is this, Mr. Chairman and members of the committee. We don't have a standardized reporting procedure on overdoses and especially the application of Narcan. So I'll give you a quick example, Mr. Chairman. Johnny's 18, he ripped his shoulder as a quarterback, he gets hooked on OxyContin, he ODs on heroin. That call goes out if you're, and this is no slight to York County, that sheriff does what he wants to do. If you OD in York County, he's not sending the sheriff deputy. Fire EMS will respond, hit Johnny with Narcan. As soon as Johnny's vitals are good, he's released back into the wild. Well, Mr. Chairman, we know that Johnny's going to reoffend. He's either going to overdose again or he's going to start doing crimes in order to pay for his habit. And what we have to do is break that cycle, Mr. Chairman. And so the plan is through the administrative process, if we can do it that way. If we can't, then I'll be back with legislation, but is to stop Johnny at that point, make sure law enforcement does respond, get a search warrant for the blood, put that blood into evidence, and give Johnny a certain amount of time to make a conscious decision to enroll in an addiction recovery program. If he doesn't, within a certain given amount of time, that officer would drop that evidence and have it processed, and we would make sure Johnny would get addiction recovery in the jail. But we don't have these programs set up in our jails at present. We have a few sheriffs that have taken the lead on this, where it's been very, very good results with regard to addiction recovery. And so this is the first step as far as many steps that to take to get this moving forward. So, Mr. Chairman, without treading on the committee's time and what's left of the committee, that's what this bill is designed to do. I forget the companion bill that's the constitutional amendment that helps, but Charles helped me draft it, and that's the bill, Mr. Chairman.
Does anybody have any questions to the patron? Anybody wish to speak in favor of this bill? How about in opposition to the bill? Come on up, Wes.
Mr. Chairman, members of the committee, Wes Nance, Bedford County, speaking on behalf of the Virginia Association of Commonwealth's Attorneys. I would say that we are simply gently objecting to this bill. We believe if you're going to move away from the primary use of asset forfeiture, which is the prosecution and investigation of drug dealers, that it needs to have the changing of the definition within the Constitution as opposed to by statute. Thank you.
May I respond to that?
Sure.
I think that's what we're trying to do with our constitutional amendment, Mr. Chairman, that will be heard next year. So I know it's in a quandary, and I know I've got this kind of in front of that, but.
Would you object to waiting until your constitutional amendment is perking along?
I don't, but I've talked with the Crime Commission about taking this issue up as well, and I know Secretary Moran and his group, they're not here now, but we're trying to put all these pieces into place. I don't have that problem, Mr. Chairman. If we want to pass it by for the year, keep it in the breast of the committee, and I can send it to the Crime Commission so they can help us with that.
What's the constitutional question again?
We can certainly put it on the list for.
I understand how the system works to pick it up.
I know
and
you
do
do.
it.
I know. All right. Senator Peake moves to pass the bill by for the year and to request that the Crime Commission put this on the list for consideration. And we'll certainly take that up when the Crime Commission takes up its list of bills for study for the next year. So with that, clerk will open the roll. All right. One more, Senator Reeves. I think this one is
I think there's some line amendments
recommendation
that
of
go
the
to this
Judicial
bill.
Council.
It is.
Senate Bill 475.
Mr. Chairman, I would move the line amendments.
All right, it's a substitute, actually. Senator Reeves moves, properly seconded. The adoption of substitute, all in favor, signify by saying aye. Aye, all opposed. Substitutes before us.
Mr. Chairman, this has to do with the several years ago when the Supreme Court came down about bird dog devices or tracking devices. Sorry, I used that term. It's just what we used in undercover narcotics. But anyway, this is a cleanup of that original bill as a result, I believe, of case law, and it's brought to me by the folks in the Commonwealth Attorneys Association and the Supreme Court. So this just
And
cleans up that language.
My understanding is it simply conforms the two processes.
Correct. When the judicial officer has to file the affidavit.
What's the change, Madam Chairman, what's the change? I don't see it. I'm missing
Charles.
something.
Mr. Chairman, the changes on lines 53 and 54, it inserts or his designee or agent.
If we need it, just stay right here.
That's the change, Mr. Chairman.
It's pretty simple.
What's the point of that?
I don't know whether Mr. Ledbetter,
I can, Mr. Chairman, David Ledbetter, Commonwealth's Attorney of Waynesboro, here on behalf of Virginia Association of Commonwealth's Attorneys. I can answer that question. The language that was in there that says that the magistrate shall file the affidavit, that was requiring somebody, him personally, to file it. He may work the night shift and have to come in the next day to file that paperwork. This mirrors language that's in 19254 that allows the magistrate to designate the next magistrate that's coming on duty or another agent in the office to do that delivery. This was requested by the magistrates to clean this up because it was just a minor issue, so they wanted to clean that up.
Mr. Chairman, has this been an issue? Some court ruled on this or something?
The way the magistrates look at, they are strictly adhering to the direct language of the statute because they're very concerned about these search warrants because they are sealed search warrants and they don't want them to reveal that. And they said, we're going to follow every letter of the law. So I've spoken with Mason Bird, the chief magistrate, or magistrate on those bird dog in this issue.
you aware of any opposition to this?
I'm not aware of any opposition with this fix. The original language we didn't care for, but this amended language we like.
Okay. All right. Any other questions? Anybody wish to speak in favor of or in opposition to this bill? Senator Reeves, you have a
Move to
motion?
report as amended.
All right, it's been moved and seconded that the bill be reported as been, or the substitute be reported. All in favor, or clerk will open the roll. And
Thank you, Mr. Chairman.
Senator Reeves, can you take the chair for the last three bills? I do believe, right?
About time we got a non-attorney in charge of courts.
What have I done?
What would be the chairman's pleasure?
Let's take up Senate Bill 654.
Committee will bring their attention to 654.
Senate Bill 654. I'm sorry, 564. Thank you.
Okay.
It's a long day.
564, non-confidential court records.
Yeah, this is a bill that the bill that I unsuccessfully made an effort to roll into Senator Stewart's fine piece of legislation dealing with open court records. And Senate Bill 564 is a bill that the clerks have worked on in conjunction with the Office of the Executive Secretary, the Daily Press, who was at the center of the request that was sent to clerks around the state asking for compilations of data. The Press Association, the Open Government Coalition, and you will remember the litigation over the past year or a couple of years dealing with the requests and who was the custodian, who owned it, and the extent to which it was discoverable and producible under the Freedom of Information request. This is a hard negotiated compromise that I believe that all of the parties in interest have agreed to. It clarifies that clerks, district and circuit court clerks, are exempt from FOIA for all court records for which the clerk is custodian, but the clerk remains subject to FOIA for its other records like administrative and financial records. So there's transparency, and citizens can see those records. It contains public access provisions for district courts and circuit courts, and provides that if the circuit, or if the courts are in possession of this aggregated data, like that which was the subject of the daily press litigation, but it belongs to the Office of the Executive Secretary, that my understanding is that the request for that has to go to the Office of the Executive Secretary, not to the individual clerks. So with that, if you have questions, I'm going to let Mr. Dix address those questions.
Mr. Chairman, I have a...
One second, Senator Edwards, let me get the substitute properly before us, okay? I'll take a motion, I'll make the motion that we get that before us. It's been seconded by Senator Peak. All those in favor, say aye.
Aye.
Any opposed? Okay, that's before us. Senator Edwards?
Yes. How does this overlay the Senator Stewart's bill that we passed, the Supreme Court
I think that
FOIA bill?
I think we made amendments to Senator Stewart's bill so as not to be in conflict with this. Do we need further amendments to this, Kristen?
No, Mr. Chairman, I looked at it again, and now it's in proper order.
All right.
Does anybody else have a question for Senator Obenshain? Does anybody have a question for Mr. Dix? If not, do we need to hear from you, Jeff? Okay.
Question, I have a question.
Go
Mr.
ahead.
Chairman, it is for Mr. Dix. What is the problem that this solution is seeking to solve?
So, Mr. Chairman, Senator Servant, the problem is that the court records access provisions are dated, and they contemplated somebody going to the courthouse and actually looking in the clerk's office under the supervision of the clerk. And today, with technology, the OES, the Office of the Executive Secretary, is the technology provider for the general district courts and for 118 of the 120 circuit courts. So what we wanted to be able to do when there's an aggregated request, instead of the individual clerks handling that who are the custodians, then OES has the technology to be able to run a report, and that report would eliminate the name of the individual, the social security of the number of the individual, and the complete date of birth. So the requestors of that information, if you're asking for 8 years of criminal records, for example, you would get what I would call the docket sheet information with those things redacted that I mentioned. But for the actual images of the court records themselves, you would go to the clerks who are the custodians of that data. And that's the construct, basically, of this bill. So what we're trying to solve is, A, how to handle bulk data requests, large aggregated report requests. B, to streamline the process for electronic access for citizens who want copies of information. And of course, we've got a provision already for lawyers and parties in the case to be able to subscribe to a system called OKRA to be able to get the data that's in their files, the actual records. So that's what we're trying to do. This is a piece of the overall puzzle, if you will, for better access to court records.
Does that answer your question, Senator Sherman? Yeah, sure.
Clarification question. How does this jive with FOIA? Are clerks already subject to FOIA?
So, Mr. Chairman, I would say on the substitute, lines 34 through 39 is the current provision exempting clerks from FOIA, district court clerks and circuit court clerks, for all records that they maintain. The question here is, what records are the clerks custodians for? And that's the correct term in the statute. So you see on lines 36 and 37, what we did is we changed it from the clerks that maintain records to clerks that are custodians for records. So I would say to you that we really haven't changed the exemption provisions. We've clarified those, and we've made it clear on lines 38 and 39, left that language that all other records, financial, administrative records, or whatever that are maintained by the clerk are subject to FOIA. The difference is that FOIA has a 5-day response, right. And for court records, oftentimes those records contain information that needs to be redacted, and the clerk needs time to go through and analyze that. It's a different type of record. So what we've agreed in this construct to is the clerk will promptly do that, but in no event later than 30 days from the date of the request, and that is acceptable to the Press Association and all the various different groups that would request the information.
Okay.
Mr. Chair,
Senator Deeds?
Mr. Dix, you
Yes, sir.
talked about redacted information. Where is that covered in the substitute?
So in the substitute, what we did on lines 50 and 51 define confidential court records and non-confidential court records, and that's referenced in section 17.1.292. So I would take you to page 7, and the confidential records are defined in 164 through 166, and the non-confidential records are defined in lines 175 through 176. So what we've done in the basic construct is to allow public access to non-confidential records. And then the records that are confidential, of course, are available for any party or their attorney to see. And then today, a person could walk in the courthouse and I could see, you know, anybody's divorce records and social security numbers and everything else, but I'd only be able to do that under the supervision of the clerk.
Mr. Chair.
Senator Deeds?
Well, so all records maintained by a clerk of court of record, felony cases are tried in courts of record.
Yes, sir.
And a felony case or any case, frankly, is held publicly, isn't it?
So, Mr. Chairman, I would say that what we did, Senator Deeds, is back in, I guess it was about 2004, when we first went online with land records for circuit court clerks, there was a question of whether the policy for online access ought to be the same as the policy as it always had been, that you could walk in and see anybody's record, whether it was your record or not. So the General Assembly decided in 2004, Delegate May had a bunch of these provisions for state agencies and local agencies, and basically established sort of a balance on a construct for privacy versus public access of electronic records. And then there's also a provision in existing law that prevents a requestor from downloading an entire court record database and making a shadow database. All of those provisions are still in other sections of the code, and those provisions have not been changed in this legislation.
But, Mr. Chair,
Senator Deeds?
you are changing the definition of confidential court records to include all records from trials and courts of record, aren't you?
So, Mr. Chairman, I
Go
would
ahead.
say on the confidential court records, what we've done on lines 164 through 166 is court records that are recognized as confidential under applicable law and sealed by a court order on line 166. And Senator Deeds, as you know, most court records are not subject to seal, and most court records are not statutorily confidential. So the key is on line 165 and 166, what records are confidential by statute, like juvenile records and so on.
Right.
And then what records are decided by the court within their discretion to seal. So
Mr.
that's the limitation
Yeah,
there.
Mr. Chairman,
Senator Edwards?
basically, the definition of confidential court records is not here. It's just referring to common law, other statutes, somewhere else. Because you're saying confidential court records are basically all records and recognized as confidential under any applicable law, pretty broad term, or sealed. That means you haven't defined what's confidential in here. You got to look at the other law to figure that out. Is that right?
So,
That's
Mr.
what it
Chairman,
says.
I'd say to Senator Edwards, so the answer to that is that if it's confidential because it's a juvenile record, for example.
Yeah, I understand.
It would remain that way.
My point is, you haven't defined confidential other than look somewhere
Trying to
else.
change that.
We're not
Yeah,
trying to
yeah, I know,
change
I
it. That's
understand.
correct.
Okay.
Yeah,
It's good.
yeah.
Good.
I think we got it. I have one question for you,
Yes,
Mr.
sir.
Dixon. And I don't practice this at all. I thought there were 2 jurisdictions in the Commonwealth that didn't line up with a lot of this stuff. Are those 2 jurisdictions are they part of this now? Am I off base on that?
No, sir. Fairfax County and the city of Alexandria do not use OES for their technology system for their court records or for their land records.
So this would not apply to them?
So it would apply, and there's language in this statute that applies to those 2 localities, that they will provide the same aggregated reports that
Okay.
OES would provide of non-confidential information, and they would, of course, be subject to the other provisions for both district court, and they're subject to district court anyway, but for the circuit court in Fairfax and Alexandria. So everybody would be subject to it.
Gotcha. I just, as a novice, I appreciate what you and Senator Obenshain have done, because I know this is a tremendous amount of work to have to coordinate all those people. So does anybody else wish to speak to
Yeah,
the bill?
Mr.
in
Chairman,
the
I have
audience?
another question.
Senator Edwards.
This really doesn't apply to the Supreme Court. That other legislation we passed. Senator Stewart's is the one
Well,
that
it
would.
does for
then apply.
compilations
For the.
expressly.
So, Mr.
Where
Chairman.
does it say that?
I mean, it addresses the daily press litigation, which was
Oh,
a
involved in that.
dispute between well, I mean, it was in Lawyers Weekly
I didn't
every
read-
week for,
okay,
for
I'm not-
months.
Senator Edwards, please
in
go
which
through the chair, please.
We had circuit court clerks saying, it's not our information. You need to ask the Supreme Court for it. And so this makes it clear that the Supreme Court is the custodian of certain data compilations, and the requests need to go to them. So
Mr.
if
Chairman,
it's owned by them.
Can you
Mr. Chairman,
point me where it is?
So
here?
on line, for example, in the circuit court, Senator Edwards, it's line 114 through line 122. So the request for the aggregated non-confidential data fields is on line 114. There's a similar provision in the district courts back on line 54. And so that's the same language that a requestor of aggregated information, instead of going to the district court clerk on line 54 or the circuit court clerk on the other line I just mentioned to you, line 114, you would make that request direct to OES. And Senator Edwards, there's one other provision relating to OES, and that's on lines 177 through 183. And what that provision says is that OES will make a compilation, I call it the docket sheet, but the publicly viewable online case information system of non-confidential information will be made available by July 1 of 2019 by OES, searchable by name statewide at free to the public. So that's the other part of this bill.
Okay, one more question, Mr. Chairman.
Senator, your last question.
Senator Stewart's bill, why do we need that if we have this? What's that doing that this is not doing?
So, Mr. Chairman, I'm not here on Senator Stewart's bill, but what I would say to Senator Stewart's bill, as I understand it, is that deals with the information that goes between the justices of the Supreme Court and
Okay.
between the justices and the Office of the Executive Secretary. That is not referenced in this bill.
Okay.
So that's what Senator Stewart's bill does as compared to this bill.
Okay, let's see if there's anybody that wants to speak against the bill. Are you non-committed?
Megan Ryan with the Coalition for Open Government. This is actually the first time I'm seeing it. I was actually not part of the discussions. I'm not quite sure how I missed all those. But they do seem to be okay. It does to our interests. I remain concerned about the broader implications for the Supreme Court records writ large. But as far as access to the databases, the language does seem fair.
Okay. Thank you, ma'am. Senator Obenstein, you want to wrap it up? And does this need to go to finance?
It does.
Mr. Chairman, it does need to go to finance, and also I believe Senator Mason requested that his Senate Bill 519 be
That's
rolled
correct.
into this bill.
Seems like so
Okay,
long
wait.
ago.
Hold on, I missed that. What was that? Can you tell me what that motion was again?
To roll Senator Mason's bill into Senate Bill 564 for us to be chief co-patrons and to report and re-refer to finance.
Okay, so Senator Obenstein has made the motion, Senator Stewart has seconded. Everybody understand what we're doing? All right, committee will vote. Did I get everybody? Hey, Stanley.
Everybody but you.
Yes, please. Okay, that bill is done. Senator Obenstein, your next bill?
Easy bill. Nobody except all the clerks in Virginia opposed this. And, but
They're
my
not here,
gosh,
so.
this is Senate Bill 980. But for you lawyers in here, you're going to listen to this and say it's about dang time, especially lawyers in the Western District of Virginia. We have been required to file pleadings in federal court electronically for over 20 years. over 20 years. We cannot go to the federal court. I remember Senator Peake and I started practicing law. We would have to run to federal court at 4:28 and beg them to keep the door open so we could hand a brief or a motion in before the door slammed and the deadline was over. Now, in Virginia, 20-some years later, we still don't have electronic filing. And every federal court in America has it. There are vendors that are servicing the federal courts quite ably. And we have lawyers who practice in multiple jurisdictions all over the Commonwealth. And to be able to file in your own jurisdiction up until midnight, we all know how valuable those last 7 hours are if you're trying to get something in, or not to have to FedEx it out the day before your opponent has an extra day to work if you're working in a different jurisdiction. It's about time that we had electronic filing mandated in Virginia. And what this does is it requires the implementation of an electronic filing system by 2019. Now, if you love this, unfortunately, it's got to go to the Finance Committee because there is a price tag that's attached to it. But if we don't do this, we're never going to get it in Virginia. The clerks and the Supreme Court keep pointing fingers at each other with deference to everybody involved and say that it is, it's our inability to decide who's going to implement this, whose system it's going to be, and this basically says the Supreme Court's going to establish it. And, I'm sorry, but if we wait around for every clerk in Virginia, with due respect to my friends and the clerks, to decide which program they're going to use, we're going to have a mishmash of filing requirements. And heck, I've got one jurisdiction in Virginia, I won't say which one, but a very large county in Virginia that charges something like $150 for access to their system, but you can't print pleadings off of it. It's different from any other system in the state. So this advocates uniformity. It requires the implementation of this. It's got some pretty aggressive dates in it, but it should, because we're 20 years behind. So it's going to need to be implemented by 2019.
Okay, so we understand what the bill is. Is there anybody else who wishes to speak in favor of the bill? Okay, Mr. Dix, you want to speak against the bill?
Reluctantly, Mr. Chairman. And,
I got you.
Let me say this. Those of you that know me know that I've worked on what I call the digital legal framework for the clerks for the last 20 years. And we've done a lot of things in that time, but it takes time to do stuff. And I apologize to Senator Obenshain. So I'm not asking for 20 years. What I suggested, and I gave Senator Obenshain earlier today some suggested amendments, and let me just explain some of the issues that I'm concerned about. First of all, what this bill would do, the way it's drafted, is we don't have updated VETA standards. We haven't updated them in a decade. And so what needs to happen, the last time it took 3 years to do that, I suggested an amendment that would allow it and require it to be done in 1 year. But we need to sit down, the clerks, OES, and VETA, and we need to update our electronic filing standards. So that's 1 year. Then the next question is, what do you do with divorce cases, with all the custody information?
Senator Stewart, let me just interrupt you real quick.
Chip,
Yes,
doesn't
sir.
this doesn't go into effect until July 1, 2019, right? It gives you time to do all that.
So, Mr. Chairman, I'd say to Senator Stewart, the suggestion, basic suggestion, let me outline the framework. The framework is, I would recommend that we put a July 1st of 2020 date on there. And then I would recommend that you require the VETA standards to be in place by July 1 of 19. I also recommend that you require OES and the clerks to form a work group to figure out how to implement this. Because, Senator Obenshain has a point. We have not focused on how to structure e-filing and who's going to do what. And right now, the clerks have what's called an Okra system. You may be familiar with it, where basically the lawyers and the parties have access to the pleadings. Therefore, you don't have to go in and redact that information. This bill, the way it's drafted right now, anybody would have access to every court record online and be able to manipulate that data and do anything with it. I would suggest to you that there are privacy issues that OES and the clerks, we need to bring that back, and I'm suggesting we bring that back by July 1st of 2019 so that we can realistically look at this, and I'm anticipating legislation in 2019 General Assembly to structure all of these things so we'll be ready by 2020. And it does have a $1.5 million price tag. And again, there are a lot of various different things that haven't been sorted out that I think if you put us on the time clock, I think we can sort it out. The last thing I would say
But
is.
isn't that what we're doing?
But
aren't we putting you on a time clock and saying, please go ahead and get it sorted out? I think that's exactly, and I got to tell you, Senator Obenshain he's getting gracious in his old age, because there was a time when he'd have put July 2018 on this bill and stood up there and beaten his fist over it to get it done. And he's moved out to July 2019 to give you all time to work through this and get it done.
So, Mr. Chairman, I would simply say that assuming it was funded, I don't know, government only moves so quickly. It took us 7 years to do land records. I don't see us being able to do civil court records in 1 year. I'm just trying to set a realistic expectation for
We
the
have
General
full
Assembly.
faith in you, Mr. Dix, to get
Mr.
this
Chair.
done.
I understand.
Mr. Dix makes good points, but
Senator Deach.
I think they can be resolved between here and finance. So I move that we report the bill, we refer it to finance.
All right. It's been moved and seconded to report the bill and refer to finance. Committee will vote.
Ayes 15, no zero.
15-0. You got to
Glad
get
I
to
was
work, Mr.
persuasive,
Dix.
Mr. Chairman. Thank you.
Senator Overton, you have one left.
Last bill. This is I think a cleanup bill, Senate Bill 566.
Committee will bring their attention to 566.
We just, I guess on Monday, expanded or recommended expanding the DNA collection for misdemeanors. And during the course of the Crime Commission work on the DNA data bank, it became apparent that we also need to look at and update our fingerprinting requirement. We have 2 jailable misdemeanors for which there is not a fingerprint requirement, one of which we just added, just one, right? Just one, we just added to the list of offenses or moving in the direction of adding to the list of offenses for which DNA collection is required, trespassing and disorderly conduct, and this simply adds those last 2 jailable misdemeanor offenses to the list of fingerprint requirements.
Anybody have a question?
And it's a unanimous recommendation of the
Chair.
Crime Commission.
Senator Deach.
I move to report.
It's been moved and seconded to report this fine bill so we can end the day. All those in favor, vote aye.
Ayes 15, no zero.
And how many more bills do we have in the committee? 28 bills left in the committee. And it's my expectation that we'll finish those on Monday.
And with that, the committee will rise.